All right, Mr. Monetis and Ms. Rowe, we're going to get on the record. I know your clients aren't out here yet, but we will loop them in. We're just going to talk about a response that we need to give. I need to give to 2 juror questions, which I left on my desk. So I'm going to go get those. And look who's here. Look, we threw a party for you. Do we have Mr. Phillips and Mr. Parks? Great. But they're all here. We got that. So you don't worry about them. We just need to bring, yeah, if you have enough people for that. I'm going to go grab those juror questions. All right. Let's get on the record, please. In State versus Parks and Phillips, it's the first day of October. This trial has now lasted more than 1 month. And we can wrap it up today. We have our defendants here along with their lawyers. Ms. Rowe, thank you for being here. We have our prosecutors, and when we left off last night, there were 2 questions from the jury that we needed to answer. One read, if we decide manslaughter on either count 1 or 2, we must choose manslaughter for both counts 1 and 2, which I took to mean must we? And then they revised a question. It now reads, party to crime and mere presence. If we choose manslaughter instead of murder, does that still indicate they are party to a crime and mere presence? You will see on the screen what I came up with this morning. I won't share that case with them, but for you case hounds, that is a case that stands for the proposition that you could be found guilty of voluntary manslaughter, felony murder, and malice murder, because it's different types of intent. And so the correct legal answer is that a defendant may be found guilty of voluntary manslaughter in 1 count, but not the other. I won't, like I said, I won't give them that case citation, but this is my proposed response to those 2 questions. It's consistent with some of what we discussed last night. But I want to give you a chance to digest it. We can wordsmith it. I will print it out, minus the case citation, and staple these 2 cards to it. All our jurors are here and they're ready to go. We have not taken their devices away. Good. So they're not deliberating yet. They don't have the evidence. We'll send whatever answer we're going to give along with the 2 note cards. I'll start with you, Mr. Greiner. I know your answer last night was let them sort it out. I don't know if that's evolved over the evening, but I'm interested in what you think about what's on the screen.
No, this is really what I wanted. This is because this reminds them to consider the entire jury charge. And so I think that's the appropriate response to their question 5, to remind them that they've got the whole jury charge to look at. And my suggestion as to question number 4 was going to be, as instructed, you're to render a decision on each defendant as to each count. And this really more or less addresses that. Okay.
So you're at peace with this?
I am at peace with that. I am at peace. But the court's earlier instruction that was given last week reminds them that they're to render a decision as to each count on each defendant. And really, I think that's the principle that they need to pay attention to. And they may even need 2 or 3 more copies of the jury charge.
Sure.
Actually, I don't know that they're actually reading the charge.
Well, the question about how do you define self-defense suggests they were not reading it, since the answer was it's in the jury charge. So if you'll ask them if they need more copies of the jury charge, not now, just when you deliver the stuff, then we can get more for them. Mr. Monetis, your thoughts about what's on the screen?
Your Honor, that last sentence I would say is not necessarily controlling in this case, although I know that's the case law. I think our case is distinguishable from Carter because it involves the death of a bystander during an alleged back and forth, and Your Honor was here for the evidence. So although criminal intent and other fact patterns can be different as far as common malice murder and voluntary manslaughter as pertaining to felony murder, here we have just one death, not the intended target of an aggravated assault if they find that. And so I don't think in this case you can find one count as manslaughter and the other count as malice murder.
But if the jury found that one of the defendants or both had the intent to kill, voluntary manslaughter has nothing to do with the intent to kill. They had the intent to kill, and someone died as a result. There's your guilty murder. But as for aggravated assault, they may have felt that some aspect of what they did was driven by that uncontrollable passion. So that's what Carter was all about. In fact, the person was found guilty of malice murder, and then it was voluntary as to the felony murder. And Justice Melton said, here's how that's not a repugnant or inconsistent verdict. And it seems like I don't know if the jury will, but a jury could do that, oh yeah, someone was going to get killed as a result of shooting in our direction, if the jury buys into we were shooting back at someone.
And Judge, that's the thing, is that there wasn't, like in Carter, there wasn't any, unlike in Carter, there wasn't any even minutia of evidence that there could be intent to kill, because it was not that under Machado, the manner is by shooting this named victim who died, who was a bystander, even if we take the state's case as true. So if there was some kind of provocation, the intent to kill would be against this unknown person.
Sure, and it transfers. That's the whole point of transferred intent. And they were instructed on that. So I agree with you, but it's transferred intent.
Well, Reggie, but if they find that person provoked them, so yeah, I'll just correct the record. If they find the person provoked them, then that to me excludes that there could have been any intent to kill, because how can you be provoked if you had the intent to kill already? Then you should be guilty on the felony murder and the house murder. So I guess
we'll see how they navigate it. But your objection is noted. And Ms. Rowe, I'm sorry it was harder for you to see. Until yesterday, we had it set up where that monitor was angled towards Mr. Rowe and Mr. Parks. But did you get a chance to look at the language?
I looked at it, and we would concur with,
Mr. Menendez?
yes.
Okay.
We would, based on what I was told, our opinion would be, or if the jury finds a defendant guilty of voluntary manslaughter on one count, would they have to find him guilty of voluntary manslaughter on the other count? Our position, of course, would be yes. They can find him not guilty on the second count of felony murder and voluntary manslaughter, but it was.
Well, that would fit what I wrote here. A defendant may be found guilty of voluntary manslaughter in one count, but not the other. So it could be, this doesn't say that the jury needs to find someone guilty of both counts 1 and 2. It's just one of them could be voluntary and the other could be something other than voluntary. And I think that's a correct statement of the law. So I'm going to leave it in. Mr. Greiner, any last thoughts?
No, Your Honor.
Okay, I will print this out. The objections have been noted. We will get this to the jury. They will begin their deliberations. And I will ask, Ms. Rowe, we may need a number for you. We had a number for Mr. Rowe, but if the jurors have a question or a verdict, I need to be able to get everyone back into court to deal with that. But I won't make you sit around while we're doing the next thing.
Okay, well, I'll be in court.
Courthouse. That's the request. Thank you.
And then, can I address the second question that they had?
Sure.
Yeah, so they
When you say second question, which one are you referring to?
the question that initially was, does party to a crime supersede manslaughter, which they then amended to party to a crime and mere presence hyphen if you choose manslaughter.
Okay, I understand which one you're talking about.
I found the first version of the question, incomprehensible, and I still feel the same about the second question. It's very alarming to me. It almost sounds like they think you can be merely present but still be not innocent. It seems to be that maybe they're misunderstanding the word mere as to be mutually exclusive to all other accountability. I would want to ask them still, you know, what do they mean by that? Because I still don't understand that question. I would ask out of caution that the court remind them that if you were to find that one or both of the defendants were merely present, then it's your duty to acquit. And
that's what I've done with this. It tells them to consider all those other important principles that are in the charge, and that's precisely what mere present says. So I understand your confusion. I share it as well. I think this is an appropriate and helpful reminder to the jury, and we'll see if it helps them navigate during this morning.
Because they had this instruction already, and they still came back with this question, so I'm still concerned.
There you go. Thank you. Pardon me? Yes. Yeah, they can go back now. Thank you. All right. Thank you for your patience. If you are here for either of the election law, election rule cases, we're going to turn to those now. And I'd ask that counsel, however you're going to space out for Abhiraman et al. Versus the State Election Board, and we've got the RNC and GRP as our two defendants. It might make more sense, even though plaintiffs usually sit on that side, there seem to be more lawyers on plaintiff's side, so you could sit where we've got two tables. I'll let you divide up however you want. Come on up. Hey, how are you? Well, we'll see. We're going to let everyone sit down and then we'll take attendance. Yeah. Take care. Maybe we'll see you soon. What? Are you going to be arguing?
Yes, Your Honor. I can come out of it. I just don't have a seat.
I think it would be easier if you sat in the front row rather than come out of the jury box to come on up when you're going to be talking. It's a funny exercise. You'll get the
We have it. Well, Bert and I, since these two, they were sorry. You're a
yeah, that's one more. No, I don't.
We'll get all that on the record. All right, let's get started. You guys gotta be in moving around and finding seats, but we're in places now. We're gonna get on the record. We have to this morning 24 CV 010786, which is Abhiraman et al. Versus the State Election Board. And we also have 24 CV 011584, Adams versus Fulton County. There's some interveners in the mix on both those cases, and we'll certainly work with them this morning as well. We're going to start with Abhiraman, and I need to figure out, mostly for the court reporter sanity, who will be speaking for the different parties involved. So let's start with plaintiffs. The original petitioners, there are many and they fall into different groups and they have different lawyers. Who will be speaking on behalf of the original petitioners?
Your Honor, Ben Phillips, and then Kurt Castor.
Okay, and Mr. Kastorf, you will be speaking on behalf of the DNC. Mr. Thorpe, you'll be speaking on behalf of all the individuals? Because Mr. Bailey represents some of the individuals.
Correct. So I will be speaking on behalf of the Democratic Party of Georgia and the voter and candidate individual plaintiffs.
All right.
And Your Honor, I think we've divided ourselves a little bit more by subject matter.
By subject matter, okay.
So I represent the Democratic National Committee, but I'll be addressing standing on behalf of all of the plaintiffs other than the DRE.
Okay, and have you introduced yourself to the court reporter so she knows who's speaking?
Yes, Kurt Castor on behalf of.
All right, Thorpe, Kastorf, sir.
Morning, Your Honor, Daniel Volchok from the Democratic National Committee. I will be speaking on the issue of the Republican interveners' equitable principles.
Okay, and we have one more person at the table. You're managing technology, or will you be for Mr. Thorpe? All right, got it. And on behalf of the election board.
Beth Young, and we have Dana Yu here with me from the Attorney General's office. I'll be arguing today.
All right, thank you for being here. And how about on behalf of the RNC and the GRP?
Morning, Your Honor, Baxter Drennan. I'll be doing the argument with Brad Carver here today.
Okay, great. Thank you both for being here. So before we dive in, I want to talk about exhibits, and then I have just some threshold questions that will help me cabin what we're going to be discussing, and then we'll get going. Exhibits, Mr. Thorpe, on behalf of the petitioners, have you worked with respondents to see if there are any objections to any of the exhibits, or are we in a position? You're in a different case, Mr. Siegelman.
I am, Your Honor. I had a quick housekeeping matter related to Adams. I was going to run by you before we got any substance on this matter.
Okay.
And that is that
Someone's computer needs to be muted. Someone's connected.
I'm working on it, Your Honor. I apologize.
Okay. We'll go with a reverb. Keep going.
all right, thank you, Your Honor. It's just if Fulton County's representative is present, but has a competing commitment this morning.
Who is that?
Sherry Allen, the chair of the Fulton County Board of Registration.
Okay. Hello, Ms. Allen.
Good morning, Your Honor.
Thank you for being here.
My question is simply, if the Adams case will be heard after Abhiraman and after the break, would it be permissible to excuse Ms. Allen just for the portion of the Abhiraman matter? She can come back for the Adams versus Fulton County matter.
That is fine with me. I can't give you a specific time when we'll be pivoting to Adams, and I can't guarantee that I wouldn't have a question for you. It probably wouldn't be for Ms. Allen, but I might have a question like, whoa, that's interesting from this case. What is the county's perspective, or what is Ms. Adams' perspective on that issue while we're talking about it? If you don't think that requires the representative from Fulton County to be here, I'm fine having people step away and come back when it makes sense for them. So I don't know if that was a helpful answer. What I can tell you is in the next 5 minutes, I won't say, let's start with Adams instead.
No, I understood, Your Honor. Thank you for that. And counsel will be present for the entire time.
Great.
Ms. Allen may step out.
Great. Sounds good.
Thank you, Your Honor.
You bet. Enjoy the competing event.
I'm representing veterans at a legal.
All right, good. So Mr. Thorpe, back to exhibits. What's the stat? I know I appreciate there's been a lot of back and forth about, hey, can't everything just be admitted up front? Because this is more about the legal argumentation than the exhibits supporting them. Where are we in your case?
I think we are there, Your Honor. We have listed 35 exhibits as plaintiff's exhibits. I think both the SEB and RNC and Georgia GOP have agreed to their admissibility, subject to a very minor caveat that I'll let Ms. Young explain. I think we've also agreed that affidavits may be considered for their substance in lieu of live testimony. And I think we've agreed that the sole SEB exhibit, which is an affidavit, should also be admitted. So I think we are squared away and would move for the introduction of all of those exhibits at the outset.
Okay, with one caveat. What's that, Ms. Young?
Simply that we reserve the right to raise objections to the use of the exhibits, such as hearsay or that kind of thing as they come up, but we have no objection to general admissibility. Making
them in the record. So I can consider as part of the record all of the exhibits from petitioner's side, as well as the lone exhibit from, it sounded like there was one, the affidavit from respondent's side.
Most of the petitioner's exhibits cover the things we would need to.
Right.
Add.
Okay. Mr. Drennan, anything you want to add in terms of exhibits?
Yes.
Good. Well, we're squared away there. That's very efficient. So here's my question. I want to know if anyone on petitioner's side disagrees, I think I know the answer, that certification of the November 5th or any election is mandatory.
We do not disagree.
Do not disagree. And Ms. Young, it sounds like the state election board does not disagree that certification is mandatory.
Correct. It's mandatory.
Mr. Drennan, you agree?
Yes, sir.
Okay. Second question. Does anyone on petitioner's side disagree that this mandatory certification must occur by 5 p.m. November 12th?
We do not.
Okay. Ms. Young?
Correct.
Mr. Drennan?
No disagreement.
All right. Last question. And I think we will be in a fairly narrow space when we're operating while we're making our arguments. Anyone on petitioner's side disagree that the state election board lacks the authority to change either the mandatory nature of certification or the deadline for it? They cannot pass a rule or regulation, anything that would make certification non-mandatory and change that deadline for this election of 5 p.m. November 12th, 2024.
I want to be sure I said this correctly. We do not disagree with that.
Okay. Ms. Young?
We do not disagree with that.
Mr. Drennan?
No disagreement.
All right. So it feels like to me, for this case, I think the other case, but I haven't asked the parties to the other case, we're debating what election superintendents, and that would include boards, but the generic term is superintendent. And so when you hear me use the word superintendent, awkward moment. Of all the rings to have, too. Not a subtle one. That superintendents, what we're debating about is what they can do in the period leading up to certification, and whether we call that work ministerial or discretionary. But we're not arguing about must there be a certification and must it be by that deadline. So based on the answers that everyone to this case has given, that's what we're debating about. So I'd like you to start, Mr. Thu. I don't know which topics, how you divided it up, but my first question for petitioners is, what is the uncertainty under which they labor? Because you are seeking declaratory relief, which says you're not certain about something, or your clients aren't certain about something. And apart from maybe your clients, I speak writ large for the petitioners who are in fact superintendents, I'm not sure what legal uncertainty any of the petitioners are laboring under such that I need to declare anything. Because if you're the party, if you are a voter, the election will be certified, must be certified, shall be certified, November 12th, 5 p.m. So other than the people who have to do the work that results in the certification, I want to understand what the uncertainty is that is properly addressable by a declaratory judgment, as opposed to an advisory opinion or a reassurance from a judge that, don't worry, your vote will count, which is an important feeling to have, but not what a judge is supposed to do.
So I want to be sure that I understand the question, Your Honor. You are setting aside the BRE member plaintiffs for this question, or you are, I'm sorry, petitioners, or you are including the BRE member petitioners?
Both. It's a two-part answer. The threshold for many of the petitioners is, what's your legal uncertainty? It's a standing argument, but I think we ought to address that first. It doesn't mean we stop the discussion. It just means that really the focus is going to be, if there's a declaratory judgment issued, it will be declaring the rights and responsibilities and clarifying, I believe, the path forward for superintendents and not for a party and not for a voter, because you're going to go to the polls and you're going to vote, regardless of what I say about the reasonable inquiry rule or the examination rule. You're going to vote. And that's sort of where we are. So it's that two-part question, and it may be different of you answer it, but that's where I'm going and working through this. I don't mean to upset the flow that you had for your presentation, but that's going to get us to the issue sooner if we focus on what that uncertainty is for those two groups, the people who actually have to do the certification, superintendents, and then everyone else who is legitimately and understandably concerned about it, but doesn't have a role to play in certification.
Understood. So just as it relates to our sort of plan for presentation, I was planning to present that as to the BRE petitioners, which include, they are members of the superintendent bodies. Mr. Castor is going to speak separately to sort of voters and organizational interests of parties. It sounds like you may be asking for that first.
First, yes.
First.
Great. I'm sorry, you may have thought you were going second, but and in terms of where you are when you speak, I don't need you to go to the podium. You're welcome. Some lawyers, they have to stand for it to work for them. Whoops.
Your Honor, because this is expedited, I have Scopus across the country online working on this, cleaning it up. I need a very good audio for them to hear it. So to their benefit, they need to really speak up if they're going to stay there or.
Well, and let's make sure your microphone should have a green light in front of it. If it's red, no one can hear you.
It has a red right now.
Okay. Did you make it green? You put your finger in that little well.
It's now green.
Oh, now the Scopus like Mr. Castor. They had no idea what Mr. Thorpe just said, but I'll let the Scopus know it was compelling. Similarly, on respondent side, is your microphone green or red?
It's red right now, Your Honor.
So let's get the little finger in the well. Ms. Yu contributing already. Did you make it green? You just tap, don't hold down, just put your finger in and tap. Good. All right. Thank you, court reporter, for doing that. All right, Mr. Castor.
Yes, Your Honor. I had planned to start by promising that I would be very brief because I was mostly going to defer to the wise counsel of Mr. Thorpe. Since you're making me go first, I might take slightly longer, but I begin by noting this court was correct in our pre-trial conference to note that it only takes one for standing. We think that the BRE plaintiffs have an extraordinarily strong sort of ironclad under recent Supreme Court jurisprudence that they have standing to bring this claim. And they do face uncertainty both about whether they do have any obligation, whether they have an obligation to hit their deadlines, because prior to the filing of these trial briefs, there was some ambiguity about whether anyone was asserting they could skip a deadline. But even assuming the finality of the deadlines are in place, the reasonable inquiry rule, what exactly it calls for them to do, is certainly in flux. So given that standing exists, I intend to be relatively brief on the remaining plaintiffs, but we do want to make a case because, among other things, even if the court is going to decide it as to BRE, this case will go on an appeal and who knows how it might come out.
Sure. And to be clear, I would like to get as close to right as possible. And if right is there is legal uncertainty for a party or for voters, I need to address that. It's just as I was processing all the very helpful briefs, and I have to admit, I did not read the amicus that was filed at 8:30 this morning. So we'll get to that later. It became clearer to me that the parties in this case actually agreed on a whole lot of what originally maybe had been part of the debate. In other words, certification is mandatory. And so that pushed things back to, well, the days leading up to it, and it would be more the actions of superintendents. So I don't want to exclude people from declaratory relief if I shouldn't, which is why I'd like to hear from you.
All right. Well, let me begin with the voter plaintiffs. The defendants don't deny that the voter petitioners have constitutional standing, and there's a reason for that. In Cobb County v. Floam, which was decided earlier this year, and defendants cite for their argument on statutory standing, the Supreme Court of Georgia unambiguously held that community stakeholders have standing to enforce a public duty and thus may seek to challenge an agency rule. I think the court's question gets at more the question of statutory standing, which ought to begin with an assessment of the words of the relevant statute. OCGA 50-1310 provides that the validity of any rule may be determined in an action for declaratory judgment when it is alleged that the rule or its threatened application interferes with or impairs the legal rights of petitioners. And the Court of Appeals has explained in Peach Hill Props 280 Georgia 624, 2006, that such language should be construed liberally wherever a legal judgment could control or direct future action, or where rights are or may in the future be affected by a statute or action.
So if everyone agrees in this case that certification is mandatory and the deadline is fixed, what are the legal rights of voters that would be interfered with through the reasonable inquiry rule and or the examination rule?
Well, voters have a legal right to have a valid, to vote, and that includes the right to have a validly cast vote counted. As an initial matter, although the parties to this litigation all appear to agree that certification is mandatory, as I mentioned, that was not clear until the trial court briefs were filed. And so we think that a clear ruling of this court benefits those plaintiffs by making sure that certification is in fact mandatory and non-discretionary. But even assuming that certification is mandatory and not discretionary, the reasonable inquiry and the examination rule seem to leave open a role for county officials in the certification process that may not have been envisioned in the statutory scheme, which leads to at least the possibility that some voters, otherwise validly cast ballots, could be excluded during the certification process and not count toward the election. And that is a cognizable harm faced by voters. Here, the voter petitioners, Johnson, Wakefield, and Waits, each have standing because they are voters of Georgia, and the uncertainty of the challenging rules that the challenge rules inject into the certification process create a risk that the county board of elections might not certify their votes, might not certify at all, or might not certify in time.
So those last two, we don't need to talk about anymore. It would just be that an individual vote might not be counted. And what is it about either of the rules that suggests that my vote wouldn't be counted?
Our concern is that the requirement of a reasonable inquiry and the examination rule create the possibility that a county official could believe that they had obligation to investigate or engage in some sort of inquiry into irregularities that are not contemplated by the statute, and could conclude that they can't certify a particular, either their entire slate of electors that they can't vote for certification, or that there are voters that they have the ability to exclude under the statute.
I don't want to get out of your lane, but someone will need to address why isn't the outcome of the scenario you described, given that everyone is saying certification is mandatory, there's a fixed deadline, a certification with reservations. I'm certifying, but I think that the votes from precinct 19 are suspect because I examined some things and I see an issue there.
Well, that would not unambiguously be a permissible outcome unless and until this court declares that, right? Our concern is that absent a ruling from this court, a county official could believe that the appropriate remedy, if they cannot determine justly that a particular vote is to be counted, to exclude it from the certification total, to abstain from a vote on certification, to refuse to vote for certification. All of these are possibilities that a county official could take that would prevent a voter from having their votes legally cast.
Under which of the two rules, or was this something you think they could have done last election?
No, we believe that the statutory scheme clearly does not allow that type of action, and the reasonable inquiry and examination components of each of the rules create the possibility that a county official could believe that. Now, it is true that the court could say, I am explicitly limiting the scope of these rules to mean that it could not mean any more than what the statutory scheme says, and here is what the statutory scheme says. But absent the court making that ruling, the voters face a harm, which is the reason they have standing. Okay. They have a basis for you issuing an order because it would not merely be advisory. The effect of you issuing that order would be to ensure, or at least significantly increase the odds that county officials apply the statute as it is written.
Okay, and this is why we're proceeding under 50-13-10, and it's a slightly different approach to declaratory judgment. It's not the classic, I don't know how to proceed because the legal rights aren't clear. A voter knows what to do. You got to go vote. And if you don't vote, your vote won't be counted. This is an attack on these rules, suggesting that the rules, if implemented without certain clarifications, could result in that outcome you described, which is a superintendent deciding, because of my examination of these records, I'm going to certify, but not include these votes in the certification. That would be the uncertainty that would result in a negative impact on a voter's rights.
That's correct, Your Honor, and it's significant, among other things, because the state election board is citing the Phillips case for the notion that there is not a statutory right. The Phillips case is primarily an interpretation of OCGA 942, the sort of general declaratory relief statute, and there's at least two important distinctions between that and 50-13-10. The first is that 942 specifically incorporates an actual case in controversy requirement. As this court may be aware in Phillips, one of the things Justice Peterson is struggling with is the fact that Georgia courts have routinely used Article 3 standing ideas and incorporated them into law when they don't clearly apply to the Georgia Constitution, which does not contain Article 3.
Right. He and Article 3 have a troubled relationship. So let's pivot, because I know you didn't want to take too long, and I've been dragging it out, and I apologize. Party uncertainty.
Party uncertainty. So in addition, both the Democratic Party of Georgia and the DNC have multiple bases for standing, both associational and organizational. I won't talk about associational extensively because the short version is, if this court concludes that voters and candidates and in fact BRE members, who also in some cases are members and constituents of the Democratic Party and the DNC, have standing, then so too do the parties. So let's move to organizational standing, because that would be, if this court were to conclude that any of those classes do not have standing, it could consider organizational standing. The organizations have standing for two separate reasons. The first is that each has been and will be injured directly by the challenged rules, because each is injured when votes for Democratic candidates are not properly certified, thus reducing the chance of Democratic candidates being elected. Likewise, DNC and DPG are each injured when citizens are denied their fundamental right to vote, because part of each organization's mission is to ensure that citizens can exercise their political freedoms. And any delay in certification or refusal to certify either the entire slate or part of the slate will thus harm DNC and DPG by infringing on that right.
Okay, so it's a natural parallel to the concern you've expressed under 50-13-10 about the voters' rights being impacted. It's the party's rights. If there is something going on with certification that you have a superintendent who feels empowered by the rules to exclude some votes, that could result in an unfavorable outcome for a candidate of the party. There's the impact.
That's correct. The one thing I'd like to stress is that the parties also do have an independent basis for organizational standing, which is that the challenge rule has injected into the certification. It will cause diversion of those organizations' resources. And we filed affidavits on these points, one from the voter protection chair of the Democratic Party and one from the DNC, that explain in very concrete terms why there is an actual effect. Because among other things, the parties, the DNC and DPG jointly run a county liaison program where both staff and volunteers reach out to the counties to work on issues that include certification, but also include a much broader basket of things, where they're going to administer early vote, how absentee ballots are going to work, how registration is going to work. And our county liaisons, in working to ensure that these new rules are not interpreted in a way that disrupts the statutory scheme, concretely have less time, resources, and political capital with the counties to express those issues. Now, that is a point that is not addressed at all in the state election board's briefing. I suspect they may point out that it is still somewhat ambiguous under Georgia law, the scope of diversion of resources standing. However, all the Georgia Supreme Court has said on that is that whatever diversion of resources standing means, it does not mean that the very cost of litigating issue itself is diversion of resources. And to be clear, the affidavits that we have in the record that we've stipulated can be agreed to the substance are not based on the litigation cost. It's based on the actual tangible diversion of resources. And the 11th Circuit in Browning, the NAACP, has clearly endorsed these theory. You've noted that the Supreme Court has not made it. Article 3 cases are not binding, but may be considered for persuasive authority. And we think that existing law effectively sets out the distinction. And the 11th Circuit also draws the same distinction the Georgia Supreme Court does about litigation costs. It's aware of that distinction and has still found diversion of resources to be a viable theory.
Okay, got it. Mr. Thorpe? The uncertainty. It's okay, you can move it. That your clients face.
Yeah, so technically, these are Mr. Bailey's clients, but I'm going to speak on their
Collectively,
behalf.
your clients.
Collectively, the petitioners face uncertainty, and I think the uncertainty is clearest with respect to BRE petitioners who are presently facing uncertainty on their multi-member boards. If possible, I'd like to share a printout and also go ahead and put this online. I think we've got copies.
That's fine. It looks like your tech assistant is making it work. While that's coming up, I'm curious, I think we can dispatch with the examination rule pretty easily because that seems to be a permissive rule. And I struggle to see how that presents uncertainty to anyone because it permits access, but doesn't obligate anyone to do anything. It says you may, but not that you must. So I'm not sure if I were a superintendent, I might feel emboldened and empowered, but not obligated to do anything that confuses me. Hey, if I want to ask for more records, I can. I'll find out what I can get if I exercise this new authority that the state board has given me. That's very different from reasonable inquiry, but I don't know that the examination rule lands. I'd like to hear how that lands your clients into a pool of uncertainty, as opposed to reasonable inquiry. That one to me on its face is vague and needs clarification.
Sure. So if folks don't mind turning to slide 9 of this presentation. I'm going to make everyone come back to all these other slides. The examination rule includes multiple sort of pieces of the puzzle. And so I want to distinguish between a couple of those pieces, which are also spoken to in the affidavits from the BRE petitioner. So point 1 within the new rule actually does impose a direct requirement on boards, and this gets at the uniformity argument that we make later, to meet and conduct a review of precinct returns on Friday at 3 p.m. Our BRE petitioners, several of them, have noted that that creates a direct and actual concrete problem for them because it requires them to meet before all of the returns are complete. The UOCAVA ballots and provisional cure ballots have not fully come back to the superintendent at that time because the deadline is actually after Friday at 3 p.m. It's Friday at 5 p.m. So that is a concrete harm that the BRE petitioner plaintiffs indicate is imposed upon them directly by the examination rule. That is separate and apart from the all election related information prong of the examination rule that I think your Honor's question is about. So I want to distinguish between the two.
Okay.
Flipping to slide 10, however, I think this gets at your question. Part 6 of the examination rule says that board members shall be permitted to examine all election-related documentation created during the conduct of elections prior to certification of results. In the abstract, that may make some sense, right? Why
doesn't it make a ton of sense? Why wouldn't we want 6?
So we want transparency as to the elections. There's no question. And there are any number of rules that say at the time that the superintendents are completing tabulation and canvassing and certification, they have access to information that is really described fully by statute. What the
But does the statute limit it to that, or does the statute say, here are the things you have to get? And now the state board has said, well, you can get more if you want it. You don't have to. You shall be permitted. So if you ask for these additional things to do your job, you should be able to have access to that.
And I think the uncertainty that that imposes on the BRE plaintiffs is that the state board does not provide, much as with reasonable inquiry, any definition or boundary on what that election-related information includes. So we see in the affidavits from the BRE petitioners concerns, present concerns about how scarce staff resources, for example, can be used during that essential week between when votes are cast and when the certification decision has to happen in order to manage escalating and cascading requests for individual, potentially ballot information from BRE members. So the Mosbacher affidavit speaks to this at paragraph 11, that's on the left, and the Abhiraman affidavit indicates the potential consequence of a circumstance in which there are just ongoing requests for more information, the consequence being that an individual member of a board may say, I have not been able to receive all election-related information, which is required under the rule, and so I cannot certify. So this is why, similar to the reasonable inquiry rule, we think that this prong of the examination rule creates an element of undefined or unbound discretion for individual BRE members to potentially deny certification.
But you must certify. Everyone agrees you must certify.
Everyone in this room agrees that you must certify. That's correct. So
I guess we need to count all the ballots in this room because they must be certified. Okay, I understand your point that the parties to this litigation agree that certification is mandatory. And so the response to the scenario you described would be, hey, I'm certifying, but the world needs to know no one let me look at these documents. And so there should be cause for concern. I asked for the ballots from precinct 9 and because of time limitations or because people don't like me, I didn't get to see them. So certification dubitante. I don't know how certified this should be, but I have to certify. So I'm certifying.
And to the extent there is evidence like that is outlined in the course of a given superintendent certification decision, we have placed where that evidence belongs. It belongs in an election contest.
Right. Or something is delivered to the relevant district attorney, as it says in the statute.
Correct. And I think what you asked Mr. Kastorf earlier is the correct way of thinking about this. The concern, the actual concern that these BRE petitioner plaintiffs have is that the rules, if implemented by the letter without any clarification, bear the risk that is not the way in which other superintendents read those rules, not the way that other actors in the course of the process read the rules. And that's not to say that our petitioner plaintiffs are not also affected in their own interactions with the other members of these multi-member boards in the interim, right? This does not all occur in a vacuum where they're just making an independent decision about certification. There are any number of resource allocation decisions, any number of decisions around staffing and availability of information that happen in a collaborative way during the tabulation, canvassing, and certification process. And those actual interests are affected presently because the rule is effective and because the rule is driving conversations in these boards. And I'm sort of repetitive on that because I think it's necessary to understand, consistent with Mr. Kastorf's discussion of Floam, that it is their conduct, our client's conduct, that is currently affected by the uncertainty in these rules. It is not only those petitioners that may choose to vote against certification or choose to delay certification. It is everyone at the level of superintendent. And that's why the need for a declaration is there. So I do want to speak to sort of two other things before we separately discuss the reasonable inquiry rule, which if we could look at slide 11. It is also the case that the BRE petitioner plaintiffs face potential sanction if the SEB interprets that they are not hewing to the letter of or the spirit of either the examination rule or the reasonable inquiry rule. So the Mosbacher affidavit at paragraph 8 indicates the concern that SB 202 allows the takeover of county boards under this 3 strikes approach. And the concern is an individual member of a given county board may come to the SEB and say, I wanted all election-related information. I was not able to get XYZ individual ballot in time for the certification decision. That is a strike. That is a concern for sanction that goes directly to cases like Black versus Bland Farms, where there is a direct impact on the petitioners that gives rise to an actual and justiciable controversy. The second, which is to echo a point that Mr. Kastorf made, is it is also in the Ugarte Baldwin affidavit that this directly affects the DPG as well, because around the state, there are DPG nominated or appointed, it depends by county, BRE petitioners, not just the 5 petitioners that are in this litigation. And so that's sort of the predicate for the associational standing argument. I want to be sure that I've addressed your questions about the examination rule.
You have.
But if I could, I would turn to the reasonable inquiry rule, because I think we've sort of set up that discussion. If we could go to slide 7. The reason we're here, honestly, is because reasonable inquiry is so undefined, right? There is a petition that offered up this rule. That petition was offered up by a member of the Fulton County Board of Elections who had just voted against certification. There is another case we are going to hear right after this one, which involved a Fulton County Board of Elections member that had voted against certification. In both of those circumstances, and this is from the petition itself, what was expressed is there were problems with the election in many places, but were they serious enough to consider not certifying the results? And so what the reasonable inquiry rule, at least as it was presented, was designed to offer was a way in which an additional non-statutory step may happen between tabulation and canvassing and the certification decision that could get at that question, that could allow, to use Mr. Heekin's words, these individuals to use their professional judgment in the certification process. I am very glad that the SEB has in this litigation conceded that this is a mandatory obligation, and even more glad that the RNC has conceded it, because that was not entirely clear from my read of their trial brief. That said, I think the proponents advancing this rule and some of the discussion that happened in the adoption of this rule indicates that there is uncertainty about the scope of how far reasonable inquiry can go. And our petitioners are already experiencing what that uncertainty looks like.
Isn't the scope, though, defined by you've got a few days? I mean, the reality is if certification is mandatory by the date we've discussed, it's what you can do. And someone noted in one of the briefs, gosh, if you work 24 hours a day to look through the things you asked for, you'd need 14 days to do it. As we'll give you this material, but you don't have 14 days. So enjoy, and you'll be making your reasonable inquiry, but you won't finish before you have to do what you have to do, which is certify. And you could add a note saying, I wish I had more time, and then the legislature could change it. But the deadline is the deadline. Get done what you can. And what is reasonable to one person might be not reasonable to another, but you're making your inquiry, and then it's wheels up at 5 p.m. on the 12th of November.
And so to the extent this court does not invalidate the reasonable inquiry rule, it should say precisely that, right? The Crawford affidavit.
Wheels up?
Yes, wheels up. The Crawford affidavit, which is on this page, actually makes exactly the point that you were just making.
Oh,
which
it's a
is
good affidavit.
A BRE member indicated that it would take weeks for them to decide whether to certify. Well, the law is that you do not have weeks. And so it is necessary, given the statements from a variety of members on these multi-member boards, that the court make clear, because the rule does not make it clear, that that certification has to happen by the deadline. It is also the case that that illustrates that there's uncertainty as to our petitioners, our clients' future conduct right now that arises directly from the rule. As Ms. Crawford states, if the same BRE member or any other member delays or refuses to certify based on either of the new rules, I am not sure how I should respond and work with them in a way that complies with both the new rules and the other statutory requirements. And that's really the central issue, is that we have 5 BRE petitioner plaintiffs here, but also DPG members across the state that are uncertain as to how they can meet both the requirements imposed by this rule for relatively unbounded discretion during that reasonable inquiry and the statutory mandatory certification deadline and requirements. That this distills it in a way that I think is quite concrete, which is the requirement under the law.
Okay.
If I could go to the next page to a couple other pieces of BRE petitioner plaintiff testimony. Further illustrations that this is concrete come from both Forsyth and Cobb. So the Tucker affidavit speaks to the situation in Forsyth, where there is the concern that a majority members of the board will in fact decline to certify, and that is a present concern. There is an attempt to have.
Help me understand, this is the second time you brought up this scenario. I'm on the board, my colleague is refusing to certify, I don't know what to do. I don't understand the origin of that. I'm certified, I know my job, I must certify. It's November 12th, I certify. I don't know why this guy's, I do know why he's not certifying, because he hasn't finished his reasonable inquiry and he's going to protest that. I think he's not complying with the statute, but why does that decision of another board member create uncertainty for me? I don't see that connection. Your affiants are not saying, we think the statute is unclear and certification is non-mandatory. They're saying it is mandatory and there's a clear deadline. So do your job. You, as that board member, would certify. And there may be larger uncertainty for voters or the party, but not that board member as to what happens if one board member doesn't certify and one does.
So these board members are members of multi-member boards that are collectively a superintendent in a given county.
Right.
The superintendent has statutory responsibilities and duties in that county, and our individual petitioners have responsibilities also to help that superintendent meet what they understand to be its statutory duties. To take the Tucker affidavit example, if the situation is that a majority of Forsyth County board members decide not to certify, the uncertainty isn't for Anita Tucker, will I cast a vote to certify or not? The uncertainty is, how do I get the superintendent, the body to which I have sworn an oath and have responsibilities, to appropriately meet its legal obligations under that circumstance?
Okay, so it would be if there was a majority not to certify, not one person doesn't certify, I don't know what to do, that creates discord, I'm uncomfortable with it. Okay, but it's still 3-1 to certify, whatever, 4-1 to certify. And that's an oddity, and maybe someone needs to deal with that in the future. But if a majority of the board does what it's supposed to do under the law, not the rules, then there's not uncertainty. But you gave me a different scenario, which I better understand. It didn't jump out from Tucker, which is I'm in the minority having certified. The majority hasn't certified. How can this body of which I'm a part comply with the law, which is, hey, it's 4:30 on the 12th. We need to do something. And 3 of you are in the corner pouting with the numbers you can't count in time. What do we do? The other 2. And I understand the issue. Okay.
Okay. So yes, I've spoken to the majority circumstance. I agree with you. The minority circumstance presents a slightly different question, but I think there's nonetheless legal uncertainty in the meantime about all of the other things we've discussed. Resource and staff allocation, the possibility that the delay, that there will just be a refusal to be present for the vote or otherwise that creates essentially logistical problems for the superintendent in meeting its obligation at this clear statutory deadline. I don't want to talk too much more about the rules. I do want to talk about how the factual uncertainty that we have just highlighted is sufficient to create a justiciable issue for that the court can decide, because I think that's part of where your questions come from. I had planned on talking first about sovereign immunity. My guess is I should sort of skip that for a moment, talk about standing for a little bit, and then come back to it if it's helpful for your honor.
Okay.
So slide 5. I mentioned this case before, Black versus Bland Farms, which was a challenge to a regulation involving Vidalia onions. I think that there are a few lines from the quoted material in this case that illustrate this precise type of uncertainty that our BRE petitioner plaintiffs, at least, if not also the voters, candidates, and parties have here.
And Bland is a APA
Yes,
deck action, not a Title IX deck action.
correct.
Okay.
Correct. And that's very important. So I've got OCGA 501310 at slide 2, but Mr. Kastorf has already talked about the language in there that's so helpful for us here, which is if a rule or its threatened application interferes with or impairs the legal rights of the petitioner, a declaratory judgment may be rendered. Bland embodies that rule and applies it in a circumstance where the plaintiff in that case has a rule that it is automatically affected by. I don't think there is any question that both the reasonable inquiry rule and the examination rule automatically affect the members of superintendents around the state. They are subject to it. There is no question about that. The question is, are they subject to it in a way that creates some actual controversy around how their future action may be directed or controlled? The answer to that is yes, in part for the reasons that we've already discussed, and in part because of something else that Bland Farms says, which is if Bland Farms fails to comply with the new regulation, the commissioner has statutory authority to impose civil and criminal penalties. The SB 202 takeover argument that is in the Mosbacher affidavit is a potent illustration of that, but so is the Forsyth example that I just gave. We would have an individual who was unable to meet her duties to that superintendent because she was outvoted by a majority that did not obey the statutory mandate. There are other cases that embody this principle as it relates to Declaratory Judgment Act and rule interpretation, but the essential principle in all of these is that what's necessary is that future conduct and really present conduct depends on resolution of uncertain legal relations. And I think we've sketched out as a factual matter why that's the case here. I want to go to the next slide, slide 6, and explain a little bit further why Cobb County versus Floam kind of proves the point, right? So this is a very recent standing case from the Georgia Supreme Court in which the court found declaratory judgment was not appropriate, but issued what we think is a very important footnote that frankly drove the way that part of this case is structured. The court made clear the fact that there are two competing maps, this was a redistricting case, does create significant uncertainty for many. Footnote 7. What does footnote 7 say? It says there's an amicus brief from the Cobb County Board of Elections and Registration pointing to its own uncertainty about whether a particular amendment is valid and asking for declaratory judgment on that. The Supreme Court was not in a position to grant that there because the BOER was not a party to the case. Here we have BRE petitioners that are party to the case, and given their duties in administering elections, that, to quote Floam, is the kind of uncertainty that would support a declaratory judgment. Jen Mosbacher is a member of the Cobb County BOER. She is a petitioner in this case, and her interest is very similar to the interest that Cobb County articulated in its amicus brief in that case. They wanted to implement a solution to a problem in time for the qualifying period that is statutory, same as the statutory period here, and they wanted to do it with enough time to undertake quality control measures, same as the resource allocation and staffing concerns that all of our BRE petitioners have indicated here. Cobb County versus Floam is powerful evidence that the BRE petitioner plaintiffs at least not only have standing, but there is an actual and justiciable controversy that allows you to render a declaratory judgment that clarifies the rights and obligations under the statute. I will flip ahead to a slightly different justiciability argument that I think is raised principally by the RNC. I don't really see the SEB making this argument in the same context, though I think my response to it answers some of the reasons why declaratory judgment is appropriate in response to SEB arguments. And that is that the RNC and Georgia GOP characterize this challenge as a facial challenge. This is on slide 12. I apologize. This is not a facial challenge, right? So the facial challenge cases that the RNC brief cites quite liberally are cases like Washington State Grange, which is a ballot design case, essentially, that is truly a facial challenge. As that case made clear, there was no evidentiary record, and the courts had no occasion to construe the law in the context of actual disputes or to accord the law a limiting construction. That is the precise opportunity that the court has here. This is not a constitutional challenge. This is not a facial challenge. This is a challenge to the validity of an administrative rule operating under the rubric of 50-1310, which has a very clear and established way of looking whether rights are affected. And they are affected here, right? So we've sort of walked through each of these examples already, but there is uncertainty that arises from the undefined but required reasonable inquiry. The Tucker affidavit speaks to that. There is present, meaning there is no future contingency required, present expenditure of time and resources in assessing current obligations about how to meet the obligations of these rules. There is concrete uncertainty about the balance between rule obligations and statutory obligations. There is the SB 202 takeover risk that we have discussed, and there is an immediate and present need to determine staffing in response to the requirements of the examination rule. Whatever issues the reasonable inquiry rule creates, and I think we've discussed this a little bit, the examination rule supercharges. The record evidence before this court demonstrates that practical reality, and that is entirely distinguishable from cases like Washington State Grange, which were facial constitutional challenges and had to be decided without any sort of evidentiary record. So I want to answer any questions that the court has. I think that generally sort of concludes both the arguments as to responding to justiciability issues that are raised by the respondents and explains why we think these rules at least purport to confer some degree, or could be read to purport some degree of impermissible discretion. There are a number of phrases that get used in the RNC brief in particular that I haven't expressly spoken to, like advisory opinion and future contingency. But I think for the variety of reasons we've discussed, those are covered by the actual controversy and justiciable controversy arguments that we've made so far. So I'll stop for a moment and see whether the court has any questions on that.
I don't. I'm trying to remember what. I'll make sure we have time for everything. Mr. Volchak, you were going to cover what part?
The Republican interveners per salary.
Okay, got it. I don't know if anyone wants to address the alleged invalidity of the rules. I mean, I think we're dealing here more in the proper space, which is how to interpret and apply these rules. But petitioners did argue a little bit, there wasn't the concise statement provided, and maybe one of the rules isn't uniform, the examination rule, because it says boards and not superintendents. And I don't want to preclude you from talking about that, but those seem to be secondary arguments rather than primary. And I didn't know if that, it doesn't sound like that falls on Mr. Volchak, so I don't know if that was part of your PowerPoint. We just didn't get to it.
It is, and it's discussed on page 13, Your Honor, but I don't want to spend more of the court's time on those arguments right now. I will say, if a concise statement of the rule in support of the rule and the reasons for overruling objections to the rule is coming, it's time.
Okay. I don't know that there's a deadline for it, but we do have an affidavit that says it's coming. So
and we do have an election in 6 weeks that will turn on in
Right.
5 weeks that will turn on that rule in part, if not invalidated or construed by this court. The immunity arguments and a response to the RNC argument about exhaustion, I think that those slides largely speak for themselves, though I am happy to address any arguments that or questions that the court might have on those.
Well, what we'll do, assuming there's enough time, I want to hear from Mr. Volchak, and then we'll hear from the respondents. And then I'll turn back to the three of you for any last word as the petitioners in this case. You may have something responsive you want to say. So let's see where we're going.
Thank you, Your Honor.
When you're ready, sir. And you don't have a microphone right there, so you got to go to the podium. Sorry.
Yeah, probably heard, but just to be sure.
So good morning, Your Honor. Again, Daniel Volchak for the Democratic National Committee. And I want to speak to, as I said, the Republican interveners' argument about Purcell, the U.S. Supreme Court's Purcell line of cases. So those cases say that ordinarily lower federal courts should not enjoin state election law shortly before an election. And the Republican interveners say that those cases preclude any relief here, but that's wrong for a couple of reasons. First, the Republican interveners' argument really turns Purcell on its head.
Isn't the larger issue, why are we getting rules right before, I mean, isn't a lot of what's flying out of the state election board right now inconsistent with the principles that animate Purcell?
Absolutely, in our view, Your Honor, yes. And so let me just
many people's view.
Certainly for my clients, Your Honor. And that's why I was saying the argument here really turns Purcell on its head, because Purcell is all about avoiding the confusion and the chaos that can result from last minute changes to state election law. Now, that may be why, Your Honor, that even the state election board is not invoking Purcell. The entity whose authority would supposedly be vindicated by applying Purcell here is not relying on the doctrine. But more directly to what you said, what I was saying, Your Honor, what the Republican interveners say is that Purcell is really concerned more about ensuring that state election law or policymaking regarding state election law is made by, quote, policymakers, not judges. That's the way they phrase it. If that is what Purcell is about, Your Honor, it certainly does not bar relief here, because our claims are entirely about defending and vindicating the policy choices about election law made by policymakers in the state legislature. We are asking this court to ensure that the state election board cannot flout, depart from, whatever rule or phrase one would want to use, the policy choices made by policymakers in the state legislature. And there's nothing about Purcell that prevents a state court from doing that. In fact, Purcell is a limitation on lower federal courts. It is not a limitation on state courts. And they have not cited any case that applied Purcell to a Georgia state court to bar relief. They have a smattering of cases from other state courts. But to be clear, if a state court is applying its own version of Purcell, it must be doing it as a matter of state law. Purcell is not itself, the U.S. Supreme Court's doctrine, binding on state courts. It's not grounded.
But setting aside the name, there's certainly policy wisdom in saying courts shouldn't interfere by changing election rules and laws on the eve of election. We call it Purcell, call it common sense, call it good judicial practice. So I'm less hung up on the name, and I agree with you that it's certainly not binding on courts here. So I think more productive is engaging policy with policy, but you started with that, which is actually what we're trying to do here is address some last minute changes to electoral procedure that's flowing from an unelected administrative body and could have an impact on the way people are applying the law that was duly considered and passed by our state legislature.
Right. Courts, like other entities, should be sensitive to timing and should be aware of the possible implications of making changes to election law shortly before an election. Now, here, of course, we are asking for a restoration of the status quo that existed until slightly before the election. So again, because Purcell is about avoiding chaos and confusion, we think it weighs in our favor here. And my last point on Purcell, Your Honor, is that I think the implications of their argument are quite extreme and unacceptable. On their view, there is no judicial check available whatsoever, state, federal, anything, for last minute changes to election law, no matter how extreme, unlawful, unconstitutional, et cetera. That is never what Purcell has been about. And so I ask the court to reject their Purcell argument.
All right. Thank you, sir. Are you good if we keep going a little bit longer? Okay. All right. I'd like now, and I don't mean to leave anyone out from petitioner side, but I think we hit the three designated speakers and pivot to Ms. Young or Mr. Drennan. I'm happy to, whatever order you all want to present, I am ready, and I appreciate your patience.
Certainly, I think I'll.
Ms. Young, you are very soft-spoken.
I'll go to the podium.
You tried.
Yes.
The lean in
that all
to the
the time.
mic didn't quite work.
That I am too soft-spoken. I want to start by saying I think that the court has picked up on a number of things that I was planning to make the subject of my argument. And the first is that, you know, with regard to both of these rules, you know, nobody is arguing that these rules were meant to be or can be read to suggest to anybody that their certification duty under the law has been called into question. And it's a fundamental principle in declaratory judgment types of cases like this, that we're going to assume public officials are going to fulfill their duties in good faith. And I will say, from the people that have worked, that I've met that work in elections, that do a very thankless and difficult job, that legal presumption is very valid in this case.
So
And-
I happen to live in a county where a member of a board didn't certify. So I'm just wondering when we need to set aside that presumption and say, but when faced with real life examples of a member of a board saying, I know it says shall, but I shall not.
So
Is that, or is the answer to say, but no one hasn't yet? And so that's where we get into this advisory space that I need to stay out of. No one, because the election hasn't happened yet, has said, I refuse to certify. And so is that not an emergency action where someone comes to a courthouse, open 24/7, on November 13th to say, well, we don't have anything from Forsyth County. And they had to certify at 5 p.m. yesterday, and they haven't. And so here's a mandamus action. Get these people to do the job they're statutorily obligated to do, and let the courts provide that relief then. Don't have to worry about Purcell, but there's not that clear and present danger. There is a forecast of it. I'm trying to balance that with, actually have real life examples of very well-meaning public officials saying, because of X, I can't certify, so I won't, even though it says shall. So walk me through that.
Well, correct, that has happened, and the petitioners pointed that out in their brief, but I'm not sure how that helps here, because all that tells you is that if somebody's going to do it, they're going to do that with or without this rule. Or actually, arguably, maybe they won't with this rule. I would like to hope that this rule will put fewer superintendents in that awkward position where they're, feeling like the deadline is coming up and they haven't gotten some information that they felt like they wanted to see, or they're nervous about certifying. And, also we don't know what the subjective intent of anyone is. I could imagine a scenario where a single member of the board might kind of do a protest vote knowing that the board is going to certify, but that, again, that's a hypothetical. But let's say you got a majority and they did not fulfill their legal duty. That sounds to me, in that particular hypothetical, like a very strong case for mandamus. And as petitioner's counsel and I can attest, having just done the ballot access cases that rocketed through this court and through the Georgia Supreme Court with, I think they called it dispatch and alacrity. There is time built into the schedule, not a lot. There'd have to be dispatch and alacrity there too. But for a mandamus remedy in that situation where you have I don't know what the hypothetical would be that would lead to this. You've got that deadline coming up and you've got 3 people that refuse to certify. What the examination rule, working in tandem with the reasonable inquiry rule, deals with that period in between and gives some flexibility, recognizing that what certification looks like in, say, Liberty or Telford County looks real different than Fulton. And it also realizes that no one election looks like another. There are all kinds of things that can and do happen in election world that might cause a superintendent to have a question. I heard lightning struck this precinct and all the machines went down. How do we know that everything, is correct? I'd like to ask some questions of the precinct leader over there about how they made sure that those numbers were accurate. There's nothing wrong with questions like that. Those are good faith types of questions, and those are the types of questions that should be able to be resolved within the time period. But if there isn't, there is provision in 493 where, as you're coming up to that deadline, you do your best and you certify and you turn whatever the issue is that you think is not quite resolved over to the district attorney.
What about the concern that the petitioners have raised about the takeover provision? So I am now tasked as a superintendent to make a reasonable inquiry. That's not optional. The examination rule says you're permitted to, you shall have access if you ask for it. But the reasonable inquiry is what you shall do. And the state election board decides that wasn't reasonable. In our eyes, that wasn't reasonable. Strike one. And in fact, there were 3 of you who weren't reasonable. Maybe that's strike 1, 2, and 3. So now we're taking over your election operations.
Again, I think that assumes an element of bad faith without any.
But maybe very
evidence
good
for that.
faith. Maybe they didn't make a reasonable inquiry. Maybe they were drinking coffee and say, "Where do I sign?" and sign here. And there's no evidence that there was a reasonable inquiry made. I'm not putting bad faith on anyone's side. I'm talking about the uncertainty because that's what the petitioners have flagged. I don't know what it means to make a reasonable inquiry. Does that mean in that 5-day window, 10 hours a day of inquiring is enough? Is 6 hours a day? Every county is different. Telfair County, it may be 20 minutes, and we counted all 11 votes, and that was great. And we hand counted. But I can tell you there are plenty of counties where you could work nonstop during those 5 days. And if your vision of reasonable inquiry was, and clearly in some people's minds, it now means hand counting ballots. Can we do that in that amount of time? I don't know. Is that what's required? So it's the uncertainty, and I'm throwing hypotheticals at you because of the uncertainty. And so what is the comfortable answer you can give me that as a superintendent, I don't run the risk of having the state board conducting an investigation and level a strike against me or my board because I didn't meet their expectation of reasonable inquiry when there's no description of what that means?
Well, again, I would say, as with any enforcement case that you have under election rules, first of all, you assume that everybody involved, the investigators and the board, are going to act in good faith. The respondent always has due process, rights to be heard.
I don't know how the strikes work. You say there's due process. The takeover provision, you're going to need to educate me. I don't know what the due process is. Does the superintendent have an opportunity to defend against the allegation, or I don't?
There's an opportunity, of course, to defend against that, and I'm trying to imagine what the hypothetical facts would be that would lead to that suggestion being made. But if there is some credible allegation of dereliction of duty, then I think that it's appropriate to bring a charge for violating a rule. But of course, you would explain why your inquiry was in fact reasonable. No, we didn't get to hand count every ballot at this precinct because that's impossible given the time constraints or the limitations on personnel. And I think the argument in terms of why your inquiry was in fact reasonable would be reasonably considered by the board. And then, there are remedies beyond that under the APA that could be pursued if that was something that the respondent was concerned about, accumulating strikes and thought it was worth their time to pursue that.
Sure.
But just, as somebody that's done enforcement cases, there are, what I tend to see is that, there's a burden of proof of preponderance of the evidence. And that matters. You're not going to have a frivolous accusation of, oh, you didn't do a reasonable inquiry because, I saw you drinking coffee and, you're in Telfair and it only took you 10 minutes. I'm going to charge you with not making a reasonable inquiry. Reasonable inquiry can be, I'm a superintendent in a small county. I have, we have one precinct and I trust that precinct manager, and that manager told me what the numbers were, and everything, there was no lightning strike, no pipes burst, no, chlorine gas plants exploded. Everything was fine. And, I can sign off on this in 5 minutes, and that can be a reasonable inquiry. in that situation. And, in other precincts, there may be a bit more. But this rule allows that flexibility, and as Your Honor pointed out, doesn't mandate anything specific. I read a really great article, line in an article that suggested that this rule was going to basically make, election superintendents live action role play as members of the Bloodhound Gang, that they were being directed to go and just, with their magnifying glasses looking for non-existent evidence of fraud. And that's not what this is doing. This is saying, make a conscious and clear decision, that the canvassing, computation, tabulation, all have the appearance of being accurate and correct, and then certify within the deadline. Everything else that we're hearing here assumes malevolent intent. And to the extent that that happens, and I certainly hope that it won't, the remedy for that is not to strike this rule, because a malevolent actor is going to act malevolently with or without this rule. And hopefully this rule will help give guidance to people who are good faith actors, but who may have felt like they weren't given the opportunity to certify in a way that they felt comfortable with before.
So a fair amount of the relief, that there is an argument made by petitioners that the rule should be invalidated, but most of the relief, sort of the main thrust of the relief, is more clarification that the rules are there. They don't take precedence over statute, and certification is mandatory, and that deadline is mandatory. And so these rules might supplement or augment a superintendent's ability to do her job. But that's what I read the declaration would say, if there's going to be a declaration. And that to me doesn't assume malintent. It is a cry for clarification, in particular from the superintendent petitioners, as opposed to the voters or the party. And I'm wondering if the board has a perspective on the value of clarifying the interplay between the rules and the statute, or maybe you started with that, which is what needs clarification. There's law and there are rules, and rules can't change the law.
Yeah, I think that's how we started our brief, was that basically you're being asked to sort of reaffirm that the law says what it says and the regulation says what it says. And to the extent that you're being asked to do anything beyond that, you'd be in advisory opinion territory, because, to the extent that, there's any question about this rule, it really should be able to be resolved by looking at the clarity that is in the statute and that is in the examination rule. But yes, you have to certify that all of these things are talking about tasks that, are consistent with the statutory framework of what happens between the time the polls close and the time of certification. You go through the canvassing, the computation, the tabulation, and you're looking to make sure that it has certain indicia of reliability. This just gives that kind of added assurance to election superintendents that, they can feel good about what they're doing. That, if they have a question, and, a good faith question, not a pretextual question that is being used as subterfuge to avoid their legal duty, but a good faith question that they'd like to have answered, if possible, before certification. You've got this window of time to do it, and it should be done if possible. If it's impracticable, 493 has a provision to address that, where you finally just put a hard stop on it and you do your best. Basically, it sounds to me like an opinion from the court would be, yes, the statute means what it says, and yes, the rule says what it says.
Right.
And that's, really might be nice in a lot of ways, but it's not really a proper use of the statutory remedy. I do want to talk just really briefly about standing. We've stipulated that the superintendents that are subject to the rule, that the criteria for statutory standing under the APA. So I don't know that how much more is needed to discuss other plaintiffs. But, with regard to the voters and the organizational plaintiffs, obviously, voters need to go vote, period. Everybody should go to the polls. And the voters are not subject to these rules. In fact, their job is done by the time the polls close. And that's when this rule begins. And I would say the same is true for the organizational plaintiffs. The organizational plaintiffs aren't subject to the rule, nor do they have, an ability to come in and direct these superintendents in doing their job, to the extent that, they have any thing to do about the rules. It's, again, to tell the voters, go vote. And, that is something that I would think that they would be doing with or without this rule. I'll talk really briefly about the sovereign immunity arguments. Basically our understanding of State versus Sass and Level at this point is in a case like this, you got to pick a lane. And
remind me, I know that the primary provision under which petitioners are traveling is the declaratory judgment action pursuant to the APA, but you allude that elsewhere they reference Title IX. And so your argument is, because you strayed over there, then you need to be suing the state and not the state election board. Correct. And we all know the consequences of getting that wrong.
Obviously under 50-1310, there is a statutory waiver under the declaratory judgment statutes. There's a statutory waiver. The thing that caught the attention of our office in reading the petition was paragraph 50 and 131 to 138, where it seems to suggest that there's a declaratory judgment claim in addition. We'll leave it to the court to determine whether that's in fact the case. And if the court does agree that that is an issue, we would be happy to work with plaintiffs, as I understand has happened in the Adams case, to be
resurrect this in a different format. Got it.
Correct.
Okay.
And you know what? I think that's all I've got for now, unless you have any questions.
No, you helped me work through the questions that I had. I appreciate your work.
Thank you.
All right. Mr. Drennan.
Good morning, Your Honor.
Good morning.
Got a PowerPoint. I'm not going to go through all of it, but I'm going to hand it out if that's okay.
That is very okay.
Then I'm going to do my bed level best to put it on the screen.
All right. You're not going to try to conscript Mr. Carver to do that?
Since we're on the record, I'm not going to.
Exactly. I noticed you keeping him away from the computer.
Yeah, for sure.
Please. Thank you.
And as luck would have it, the arguments today have not been presented in the order that I anticipated.
Never are.
So we're going to jump around briefly. I'm going to share my screen and get started. Yes, ma'am. As soon as I can accurately share the correct screen, I will do that. There we go. All right. Your Honor, I'm happy to start wherever the court wants me to, but
Well, give me an overview, please, of what the parties are going to be addressing. Ms. Young tackled some of the perspective from the respondent side, and so I'm assuming you'll cover something different. And I didn't remember, had you foreshadowed when we first started what that was?
Well, Your Honor, I think 3, maybe 4 points. 1, there's not a bona fide dispute here. 2, the rules are consistent with the law. And frankly, if someone has a concern about what their obligation is under the rules, they should look to the law because those same obligations exist under the law. 3rd, the rules are actually necessary to ensure votes are counted. There are examples where that hasn't occurred. And then 4th, I'll briefly address the Purcell arguments.
Okay. What I'd like to start with then is not that the rules are necessary. I follow that argument, but whether they are sufficiently clear that they don't require any declaration, because that's really what we're here for, is this question about, well, okay, the rules are here, and setting aside the challenge to validity because there hasn't been a concise statement yet, or whether the examination rule isn't sufficiently uniform because it doesn't say superintendents, it says boards. I don't think we need to go there. The rules say what they say. They certainly can't countermand or overrule or modify the statute, so they supplement it. But if they supplement it in a way that creates uncertainty that is potentially harmful, that's the main argument I'm hearing, that superintendents are saying, we don't know how to proceed, or the way we're proceeding is going to cost a lot of money. There's uncertainty, there's expense, there's harm, et cetera. That's where I think you'd need to push back if you think no relief should be granted, although the relief that I think is primarily contemplated here isn't saying the rules are out. It's simply saying the rules operate within this universe, which I think Ms. Young's point was, yeah, they operate in the universe of the law, which no one is disputing.
And frankly, Your Honor, I don't want to borrow a phrase from over egg the pudding. I agree. The first point of construction of these rules needs to be that they're to be read consistent with the law as it exists. And 21-270 of the Georgia Code requires an inspection systematically and thoroughly of the conduct of elections. And this is by a superintendent, or as the courts noted, superintendent and boards can be used effectively the same. So the law requires an inspection of the conduct of the primaries and elections, and it requires superintendents to receive from the poll officers the returns, to canvass and compute those, and to certify the results. So, and I'll supplement with a second code section, 21-493 requires a superintendent to examine all of the registration and primary or election documents. And it says here, whatever, because that's what the code section says. But superintendents are required, before the rules ever come into existence, to examine, and it says shall, so this is a mandatory provision of the law. They must examine all the documents related to an election. I'll hopefully fix it whatsoever. Whatever those documents are, they're required to do it. And then to supplement the point, if error or fraud is discovered, they're required still to compute and certify the votes, but they're required to do it in the word of the legislature justly, regardless of any fraud or erroneous returns presented, and then to report those facts to the appropriate district attorney. So if we read
before, can you go back to that slide, please? The phrase, all of the registration, and here it would be election documents, not primary documents. Is that phrase defined elsewhere such that really the statute limits superintendents to looking at certain things? And so then the rule is changing the statute because it's saying you can look at other things, and maybe a reasonable inquiry means you better look at other things, which is not all of the registration and election documents. All is a big word, only 3 letters, but pretty expansive. But if that phrase, registration and primary or election documents, is defined elsewhere and it's limited, then we now do have some tension between the rules and the statutorily defined role of the superintendent.
And Your Honor, I'm sure somebody will correct me if I'm wrong. It's hard for me to prove a negative standing here, but I'm not aware of it being defined somewhere else. And
okay, I didn't mean like in Title 5, but you'd probably be in 493. 493 is very long and it says a lot of stuff. I just wasn't sure if in Chapter 2 of Title 21 there was some definition of that phrase. I don't know otherwise, so I'm not trying to trip you up.
I read it. I don't recall that.
Okay, me neither.
But I agree with you that one, this is mandatory, and two, it's very expansive. To use the phrase all and whatever would suggest all the documents that there are related to it for that particular jurisdiction, whatever those documents are. But collectively, the requirements under Georgia Code, a superintendent is required to inspect systematically and thoroughly how an election was conducted, to examine all the documents associated with the election, to canvass and compute the returns, to compute and certify the votes justly, and then to refer fraud or other discrepancies to the appropriate district attorney. And as we've said here today, I have not heard the petitioners cite one aspect of either rule that is inconsistent or different than what's required here under the law. And I think that's a requirement that they must make to have this court invalidate the rules, or, I mean, frankly, to other bodies provide guidance. We talked about that briefly. The City of Atlanta versus Independent School System requires it for this court to issue a decision. It must relate to an immediate legal consequence. We don't have that here. Mere disagreement over an abstract meeting or the potential validity aren't sufficient. I mean, again, I tried to count, but I lost count. Whether it's in the affidavits or in the argument today, there's a possibility this may occur. Someone may say this, someone may do this. They might not certify. All these things are mere possibilities or potential things that could occur, but none of them are actual immediate legal consequences under the rule. And I don't think this court can issue an opinion based on that. Your Honor, with regard to Purcell, one, that this court couldn't apply Purcell or some similar rule. I think they've missed that here. The court, in its equitable power, certainly could apply its own judgment similar to Purcell. Purcell, the purpose of Purcell is really a separation of powers issue. We have an executive branch that writes rules or expounds upon rules, and Purcell respects that by saying we've got experts in policy to make election rules. The court's not going to substitute its opinion for those rules. I need to take a break.
No, I just wanted to, everything good back there? Okay.
Sure. And to not substitute its opinions for what those rules should be, but instead, particularly when you're this close to election, but to instead follow what those policymakers and experts have put in place.
Right, but help me address the tension created by the fact that it's good policy. And I don't think really there needs to be a big debate about whether Purcell, the case, is importable to Georgia. Good policy ought to be importable into all 50 states. But we're dealing with a situation where new rules seem to pop up every 20 minutes and the election is getting closer, not further away. That would seem to create a natural tension where it can't be that there reaches a point where courts aren't allowed to be called into service by concerned litigants, and yet an agency can keep generating rules. Because then that would mean that there's a window where unreviewable rules can be issued. They could be procedurally defective, they could be substantively defective, they could be unconstitutional, and they're incapable of review because this agency, this rulemaking body says, oh, we're within the Purcell window. Now's the perfect time to say, let's count ballots by hand. And we know a court can't look at that new rule because it's too close to the election.
And I can appreciate the court's concern there. I don't think that's what we have here. Here we have a rule that was first submitted back in April, or rules that were first submitted back in April. The state election board completed its process for addressing those rules in August. And again, I don't know how much this is really Purcell, but if you take the principles of Purcell, look at the rules that were promulgated and look at the actual law, we're not changing the law. Reinforcing or reemphasizing, I think might be the best ways to describe it, the law that was in place beforehand. So if someone has a concern that something's changed, they need to go back and look at what the law required. They should not have a concern that they're doing something new. They're being, again, reinforced, reemphasized to follow the law as it existed. And because of that, I don't think there's a concern that there's some new requirement that's taken place. And I think Purcell would, at least the principles of Purcell would be applicable and controlling on that. Your Honor, recognizing the time, I'm happy to take any other questions.
Let me see. Nope, I don't think so. I appreciate it.
Thank you, Your Honor.
Thank you. Let's pivot back to petitioners. Happy to hear your responses in general, but I want to start with an exchange I had with Mr. Drennan. And I've been trying to find, 493 has so many sections and so many words, but he seized upon a section where the language was superintendent should look at all records. I'm paraphrasing and I can't find it, not because it's not in there, but just because there are many very long paragraphs. But if 493, so we're clear, OCGA 21-493 already says superintendent should look at everything. How is either rule that we're here to discuss doing anything other than here's another way to put 493? Let's discuss.
So I don't have the full text of 493B, 493 in front of me, but I believe the reference there is to 493B. And so I would commend you to read 493B because I believe that 493B refers to an if-then circumstance. If a particular discrepancy arises, it is then appropriate for the superintendent to evaluate those documents. And so I actually think that's a fairly good illustration of our argument, rather than the statutory scheme in which the decision to look at all of those documents arises from a particular circumstance described by statute. The examination rule modifies that to say that it is actually just generally available at the whim of any member of any superintendent.
Got it. And you're right. Now that I have all of B here and B requires the superintendent before computing votes cast to compare registration figures with certificates. And it's if upon consideration of those things, it appears that an example would be there are 800 registered voters, but there are 801 votes. Uh-oh. Then you take this deep dive and look at everything. So that makes sense. Superintendents are empowered to take a deep dive if that initial check, which is what the statute requires in general, doesn't add up. And so your response, Mr. Thorpe, is that the two rules make that now the norm. You can take a deep dive anywhere, anytime. I don't know that's necessarily a bad thing, but it has the ripple effects that you've described that generate for some of your clients the uncertainty that you've also described. But that helps clear up.
In our view, it yields some degree of purported discretion on the part of individual members of superintendents. And that connects to what I think is a broader theme as you read our petition, which is a lot of these choices have been made by the General Assembly about if-when circumstances in which superintendents will look at specified information. This is a comprehensive, and I think we call it a reticulated scheme, meaning there's a network of steps that happen along the way in order for tabulation and canvassing to occur. Our concern with both of these rules, frankly, is that they interpose this additional layer of inquiry that is totally undefined. And I think some of the colloquy with the SEB on this question illustrates that it's totally undefined, and allows individual members not to follow those statutory requirements, but to determine spaces where they think additional inquiry is necessary, but the Georgia General Assembly did not. And so that gets back to the question you asked at the outset, which is, does anyone think that these SEB rules can expand upon the authority or change the statute? I think everyone's answer was no.
The corollary or the companion to that question was, is there anything in the statute that says you can't do these things? In other words, do the rules conflict with? And I don't view it as a conflict if 493B says, if in a certain scenario, your spider senses start tingling, you can go through all the records. And here's what qualifies. And now there's a rule that says, to be thorough, if you want to look through all the records because you're being tasked to certify the election results for your county, you can do that. That is expansive. It changes the role of a superintendent. That may have unintended consequences. It may create uncertainty, but I have not identified any provision in Chapter 2 of Title 21 with which that is inconsistent.
So it is not certainly in conflict. Otherwise, we would only be making the argument that the rules are necessarily invalid, not
Okay.
that they can be construed consistent with law. But I would give you an example, and this, I don't have a pin site to this, though we can certainly provide it. In the discussion of the initial Heekin petition, the reasonable inquiry rule, there is a discussion that SEB member King participates in, where she is asking about whether the question of whether a vote is legally cast is part of what can be evaluated in the discussion of reasonable inquiry. That is an example of something that, from our perspective, goes so wildly beyond the steps prescribed by statute. And I'm not saying that to attribute any sort of bad faith to the question. It's just not a question that is anticipated by the steps that the superintendent is involved in at that time in the canvassing, tabulation, and certification
Right, or
process.
how, not what a superintendent's qualified to opine on either. Okay.
I'm in complete agreement. So I think that's an illustration of why something that is not directly in conflict can nonetheless sort of supplement in a way that at least seeks to expand or arguably expands the SEB's authority. So I also think that speaks to some of SEB counsel's example, Ms. Young's examples of, how do we have flexibility to resolve questions? Our argument is that the reasonable inquiry rule provides all kinds of flexibility, but no direction, right? There is no definition in the rule that helps superintendents understand when reasonable inquiry has been satisfied. And so it is then left to the determinations of individual actors. And I think we have plenty of practical evidence, as Your Honor outlined, that in some circumstances that may support a decision to delay or otherwise vote against individually or as a board certification. I do want to address Ms. Young's argument about whether this is better as an emergency action that would get filed at 6 p.m. on November 12th. And in our view—
So I want to be clear, I didn't hear Ms. Young say it's better. My exchange with Ms. Young was, isn't that the way to handle this? That the respondent's perspective is, these are potential concerns. Your perspective is, no, they're real right now. Read the affidavits. Today they're real. Pushback is no, because none of this has happened and we don't have a non-certification. We don't have a Forsyth where 3 refuse to certify and 2 are ready to certify. Should that come up, there is a tool out there, and that's mandamus. And you go to a judge in Forsyth, not in Fulton, and get that addressed. That's what I heard her say. Not better, but if you are pulling tools out of the toolkit, it's a Phillips head for a Phillips screw, and you are trying to use a flathead in a Phillips screw.
That is a much better characterization of her argument. Our argument is that it is definitively worse. And the reason why is that this does present an actual and justiciable controversy, and the circumstance in which we or whoever has to bring a mandamus action on the evening of the 12th, what we need in that circumstance is a clear judicial pronouncement that the law requires X. And that is part of what we are seeking in this case, is clarity that will govern all actors in that circumstance. We think we've brought a case that allows this court and whatever reviewing courts to illustrate that by way of a binding opinion that we may need to use on November 12th or whenever such an action needs to be brought. But to wait, to not decide that case when we think it's decidable is a definitively worse outcome for all parties involved.
Okay.
There are 3 other very sort of grab bag arguments that I wanted to address, if Your Honor would indulge them. They're very
Give me
short.
1 second. Is Deputy Gordon around? Oh. Yes, please. Thanks. All right. Yes, 3 brief arguments.
And it's actually just 2.
Even better.
I reduced my count. So the first is with respect to standing cases like Atlanta versus APS. I think if you review those cases, what you will find is those future contingencies were not examples like we have here, where a certification vote is definitively going to happen. The question in Atlanta versus APS was where Atlanta had annexed a bank building that had no people in it. Could APS use that to challenge a provision that would be applicable if Atlanta had annexed somewhere with people that would have tax revenue that could go to the schools?
fundamentally different circumstance, not a future contingency. What we have here, for the reasons we've discussed, we don't think is a future contingency.
Okay.
Lastly is the sovereign immunity point. To be clear, we are not making a declaratory judgment claim that goes beyond 50-1310. We are not making a claim that is pursuant in any way to paragraph 5. This court should find that to the extent it has to interpret what sort of declaratory judgment claim we are bringing. The reason that 942 and 943 are cited in the jurisdictional part of our petition is that 50-1310C expressly incorporates the provisions of Title 4 of Chapter 4 of Title 9, and 942 says it's the superior courts that have jurisdiction.
I took it more as procedural. I mean, you
Correct.
the jurisdictional hook that keeps you away from SAS Group and all that cluster is Title 50. But it then references, it doesn't have its own declaratory judgment law in terms of procedure. It says, see Title 9 for how you move forward with the declaratory judgment that you're pursuing under the APA.
Correct.
Okay.
And that is the reason we have cited those provisions. And more than that, 50-1310 requires that we name the agency as a party. So
Right.
that was part of the
Okay.
reason we did that.
All right, got it. Are they done? All right. Ms. Young and Mr. Drennan, you had less time because you covered what you needed to very efficiently, but I want to make sure if there's anything else you want to add, you both have an opportunity to do that. And then we're going to wrap on Abhiraman, take a break. I have a verdict. And then when we come back, we'll pivot to Adams versus Fulton County. Anything, Ms. Young, and you don't have to add anything, but I don't want respondents to say, wait a minute, these petitioners talk forever and we didn't talk a lot. That's okay. There's a celebration around that, but I want to make sure if there's anything you want to add, you get a chance to do that.
Just two real quick points. I don't think it'll take very long, but a comment was made about during discussions on the rule, a statement made by one of the members about looking at whether or not the votes were legally cast. I wanted to say two things about that. First of all, there are many cases, one of them's Olevic versus State, that says when we're looking at the intent of a statute or a rule, we don't look at comments like that and that's for good reason. Having sat through a lot of these board meetings, there are a lot of questions and ideas that get knocked around, and it is not imputable to the rule or to the board's decisions itself when members ask questions that may in hindsight seem a little strange or unusual. It's sort of the nature of the process.
Sure.
The second thing we didn't really get I forgot to get into because I was off track on my notes, but I wanted to briefly mention the procedural issue that the petitioners raised with the notice and comment, and just say a couple of things
This is
about
the
that.
concise statement that is supposedly on its way? Or you're referring to
Correct.
something different?
Yes.
Okay.
Concise statement. First of all, for the reasonable inquiry rule, it's not required because it's an amendment. Second of all, for the examination rule, I'll say that when it is forthcoming, I don't think the law puts a specific deadline on that. And the other thing I'll say is, and I feel obligated for their staff who is inundated, to say that, not seeing out of a multi-page document a line in there and recognizing it as an action item can't possibly be the standard that would invalidate a rule. And now that they're aware of it, it will get taken care of. But
Okay.
I just
Well, that
wanted
seems-
to make a little plea for some, the substantial compliance there. And the other thing is, there is no shortage of public comment on this rule that the board has heard and the public has heard. So,
Okay. No, I hear you. I don't know that substantial compliance fits this one because it seems to be part of, can't remember A and C, but there were certain aspects where it was exact compliance or express compliance, a phrase I hadn't seen before. And I think that concise statement falls into that window. But that statute also says it's due after the rule is promulgated. And so you haven't missed that deadline because we're in that infinite period of after the rule is promulgated. Sooner will be better.
Yes,
All
thank
right.
you.
Thank you. Mr. Drennan?
Your Honor, two very brief points.
Mhm.
One, we were talking about 21-2-493 with regard to the broad scope of reviewing documents.
Yes, sir.
And I would just also point the court to 21-270 that again makes it mandatory for an election superintendent to systematically and thoroughly evaluate the conduct of primaries and elections in the precincts, and the court can read the rest of it. And then the last point, Your Honor, to the extent they're asking the.
Which, just so that I have the, because I am taking notes here, 21-270 has 1 through
8 and 9. Your
8
Honor.
and 9. Okay,
Thank you for asking for that.
great.
And then the last point, Your Honor, to the extent you're being asked to issue an opinion that would provide further guidance on these rules, effectively what the petitioners are asking you for is for the court to say what is reasonable across all counties in the state before any factual occurrences have been made. I'm not sure that there could be anything more speculative than asking for that. And again, I think that further shows why this court should not issue a ruling in this case, or one in favor of the rules is what should be issued, excuse me. Thank you,
Okay.
Your Honor.
Thank you. I appreciate the input from all of you. There was a lot of writing done on a short schedule. That's been valuable. And I appreciate your comments today. I'm going to ask those of you who are at the tables now to step back. We have to take the verdict in the criminal case. Promise the folks in Adams versus Fulton County, we will have a full hearing of your issues as well. But we got to do this verdict first. So you're free to stay in the courtroom. You don't have to.
Would you mind if I
But
ask-
I just need the tables.
Would you mind, just a very quick housekeeping question as to exhibits? Would you like copies of the exhibits that we moved for?
So great question. I believe we have digital copies of everyone's exhibits. They were emailed, and so I've got them. But to be made part of the record during the break, you should speak with our court reporter to figure out the best way for her to get those exhibits.
We will do that. Thank
Okay?
you.
Thank you so much.
Please.
Ms. Rivers, are you ready? Okay. Just have to reorient. We're now getting on the record in State versus Parks and Phillips. We have our prosecutors here. Mr. Manetis and his client is here. Mr. Rowe is back. Good to see you, sir. The other Rowe did a phenomenal job in your stead. We voted for her to be a permanent replacement, but here you are. And Mr. Parks is here. Deputy Gordon tells me that the jurors have reached a verdict in both defendants' cases. And so it is my intention to bring them out here so we can receive that verdict. Mr. Greiner, anything we need to discuss before the jurors come out?
No, Your Honor.
Mr. Manetis?
No, Your Honor.
Mr. Rowe?
Okay.
So here's how this is going to flow. We'll get the verdict. It'll get published. You all will look at it. We'll receive it, whatever it is. I will then have the jurors go back into the jury room. I'll thank them. And then I'm going to go back and get their letters for being here and talk with them briefly. I will ask them if they want to interact with you all. And if they want to, we'll make that happen. It won't be the normal, they come into the jury box and you chat with them, because I need to get back to the hearing I'm in the midst of. I don't like it if they're stuck in the jury room to do that. So we may see if there's an open courtroom that they could go to and you all could chat with them if they want to. They may say, gosh, we started a Wednesday ago and we're done. But I always try to make jurors available for attorney feedback, assuming you all want that. If you don't, then I don't need to make it available. You do?
Oh, I'm sorry.
Well, I mean, is there?
Yes, I'd like that available.
Okay, Mr. Greiner?
Yes, Your Honor. If they're
Okay.
willing to talk,
All right.
I'm willing to listen.
All right. So we're ready for the jury, Mr. Greiner,
Yes, Your Honor.
Manetis,
Yes, Your Honor.
and Rowe.
Okay.
Let's bring them in, please.
All rise to the jury. President County Court.
Thank you, Deputy Gordon. Welcome back, ladies and gentlemen. Appreciate you being here Tuesday of yet another week. Deputy Gordon informed me that you all have reached a verdict in both defendants' cases. Is that correct?
Correct.
All right. Are you the foreperson? If you could hand Deputy Gordon the verdicts, please.
You may be seated.
Sorry. Thank you. Didn't foresee this trial going into October. We had to correct the month, at least not the year. All right, sir, if you would stand, I need to ask you a few questions. You and your colleagues have reached a unanimous verdict, and you filled out both verdict forms, signed and dated them. All right. If you would please read the verdict into the record.
I'm going through every charge.
Yep. So you'll say, I don't know if you have Parks or Phillips, but you'll say, as to defendant Parks, we the jury count one, whatever you did.
As the jury for the case of State of Georgia versus Tamario Phillips, for count one, we the jury find defendant guilty of murder. For count two, felony murder, aggravated assault, we the jury find the defendant guilty of felony murder. For count three, felony murder, criminal damage to property, we find the defendant guilty. For count four, aggravated assault, we find the defendant guilty. For count 5, criminal damage to property, we the jury find the defendant guilty. For count 6, possession of a firearm during the commission of a felony, we the jury find the defendant guilty. For the case of the state of Georgia versus Mars Parks, we the jury for count 1 find the defendant guilty of murder. For count 2, felony murder, aggravated assault, we the jury find the defendant guilty of felony murder. For count 3, felony murder, criminal damage to property, we the jury find the defendant guilty. For count 4, aggravated assault, we the jury find the defendant guilty. For count 5, criminal damage to property, we the jury find the defendant guilty. For count 6, possession of a firearm during the commission of a felony, we the jury find the defendant guilty.
Deputy Gordon, if you would deliver the verdicts to Mr. Griner, please. And counsel, if the three of you would review those verdict forms, please. Mr. Griner, do you have any objection to the form of the verdicts?
No, Your Honor.
Mr. Menettis, do you have any objection to the form of Mr. Phillips's verdict?
No, Your Honor.
Mr. Rowe, do you have any objection to the form of Mr. Parks's verdict?
I'm good.
All right, Mr. Griner, anything else from the state before I release the jury?
No, Your Honor.
Mr. Menettis?
No, Your Honor.
Mr. Rowe?
Judge, can you call the jury?
We can. Ladies and gentlemen, I'm going to ask each of you the same three questions. When I call your name, if you would please stand and respond to those questions. Ms. Contreras, was the verdict that you heard here your verdict in the jury room?
Yes.
And did you freely and voluntarily enter into that verdict?
Yes.
And is it still your verdict as to both defendants? Thank you. Ms. Smith, was the verdict here in court your verdict in the jury room? Is that a verdict you freely and voluntarily join in? Does it remain your verdict as to both defendants? Thank you. Ms. Simpson, was the verdict read in court your verdict in the jury room? Did you freely and voluntarily enter into that verdict? Does it remain your verdict as to both defendants? Thank you. Ms. Reddick. Oops, Ms. Reddick didn't show up. Mr. Head. Was the verdict read here in court your verdict in the jury room?
Yes.
Did you freely and voluntarily enter into that verdict?
Yes.
And does it remain your verdict as to both defendants?
Yes.
Thank you. Ms. Black. Was the verdict read in court your verdict in the jury room? Did you freely and voluntarily enter into that verdict? And does it remain your verdict as to both defendants? Thank you. Mr. DeGroot, was the verdict read in court your verdict in the jury room?
Yes.
Did you freely and voluntarily join in that verdict?
Yes.
Is it still your verdict as to both defendants?
Yes.
Thank you. Ms. Collins, was the verdict read in court your verdict in the jury room? Did you freely and voluntarily enter into that verdict? Is it still your verdict as to both defendants? Thank you. Ms. Nichols, was the verdict read in court your verdict in the jury room? Did you freely and voluntarily join in that verdict? And is it still your verdict as to both defendants? Thank you. Ms. Huggins, was the verdict read in court your verdict in the jury room? Did you freely and voluntarily join in that verdict? Is it still your verdict as to both defendants? Thank you. Ms. Greenlee, was the verdict read in court your verdict in the jury room? Did you freely and voluntarily enter into that verdict? Does it remain your verdict as to both defendants? Thank you. Mr. Gillespie, was the verdict that you read here in court your verdict in the jury room?
Yes.
And did you freely and voluntarily enter into it? Is it still your verdict as to both defendants? Thank you. Ms. Staples? Was the verdict read in court your verdict in the jury room? Did you freely and voluntarily enter into it? And is it still your verdict as to both defendants? Yes? Yes. Thank you. Ladies and gentlemen, I want to, on behalf of the state as well as counsel for both defendants, thank you for your time. Clearly, this was an important issue for everyone involved. It was a difficult issue as demonstrated by the length of your deliberations, but your focus and dedication has closed a chapter for the victim's family and started a new chapter for the defendants. We couldn't move this forward without the time you've given. It lasted longer than everyone forecast, and we had a natural disaster in the middle of it, and yet you persisted. That is civic duty above and beyond. So thank you for doing that. I'm going to ask you to go back to the jury room. We're going to return your devices. We've got letter certifying where you've been. Just need to thank you a little bit more, and we'll get you on your way. Okay? Appreciate your time. You all can be seated. Mr. Manetis, I'm going to talk to you and Mr. Rowe about sentencing timing. We can't do it right now because of this other hearing. I could do we have time at the end of the day? I don't know how long. Our calendars, we have more calendars later this afternoon. We could do it this afternoon, but I need to know if that works for your schedule and what you might want to be able to present on behalf of Mr. Phillips.
Your Honor, I'd like to present on a separate day. I have extensive mitigation, social history that involves some witnesses that aren't available today, but
That's all you need to say. We'll do it on another day. Ms. Nelson will coordinate with you. And that basically answers it for you, Mr. Rowe, because we're going to sentence on the same day at the same time for both defendants. So Ms. Nelson will work with Mr. Greiner, Ms. Porter, Manetis, and Rowe, and we'll figure out a date and time for sentencing. It will be in person, and we'll handle it then. Mr. Greiner, anything else before we adjourn?
No, Your Honor.
Thank you for your work on this case.
Yes, Your Honor.
Mr. Manetis, anything else before we adjourn?
no, Your Honor.
Thank you for your work on behalf of Mr. Phillips. Mr. Rowe, anything on behalf of Mr. Parks?
No, Judge, I would actually say the same announcement, and that is driving a different thing, but other than that, nothing else.
Good. All right. Thank you for your work on behalf of Mr. Parks.
Y'all gonna be on that side?
I do need to. Here's a section for my computer. Okay. This is an old situation. The old one? So I got it. This one. This is to be determined. Yeah, that's just on. I sent this one.
Okay.
Yes. Should be towards the end. Yeah, I made sure we got this.
Are you gonna be around for the second? Did you want a copy of the transcript?
Yeah, you may ask if you turn it out. Yes. Yeah. Okay, yeah, the last, oh, you're out with you, that's not fair at all. Put you in. It's, okay.
Just. That's really kind of big. Yeah, but this is just the form. Right.
Yeah.
So, we don't have any, it's just.
That the other one?
So this is what the, yeah, so we need the. I just want to say this is fine. Not put on their app, but it's in the voice.
Right, no, I understand. I just, I'm not clear.
Sad to say, our chairs here, she's me. Well, maybe we'll just try to show it. Yeah, okay, we can say what we're something to your protection.
Yeah, he might.
Got a state seal on it. The one I sent.
Yeah, this one is said, we know this is the one they have to do is, yeah.
I just didn't choose actually. I have it in the digital. I had it one. Did I have it?
He needs someone who can. He needs someone who can serve.
Yeah, that's. Right.
He just needs to, right?
No, I don't think you were, I'm just gonna throw the place. You have it. Exactly.
Well, actually just filed him with.
Yeah, because I copied it. Anyway, I just said, you just ordered off the one I said.
It'll probably just be. Yeah, they just, I think I put the.
No, it's your thing for G.
This is still. Yeah, yeah. It doesn't.
What is this?
The American Overseas.
Just we have that. So instead of art,
I think so.
we just have a really legal question.
I think I'm just perusing it, but it looks like exactly. Now I gotta tell her it's first. Yeah, I just refile because it's to
No, but he said we wanted.
We don't even feel.
David Alexander. Yes, he's probably. He's down. Your mind is.
Eight E. 8E. They see, where'd the prosecutors go? Oh, well, they're lost. 8E. Thank you both. Appreciate it. See you soon. Is the notice just, we're appealing? Is it an emergency appeal?
I think it's just basic.
A regular appeal? Okay. Are you ready to go back on the record? Great. All right, let's get on the record, please, in 24 CV 011584, which is Adams versus Fulton County and the Democratic National Party and the Democratic Party of Georgia. Appreciate your patience. We are going to get started now. If I could have the appearances for plaintiff petitioner Adams. Oh, we're seated in the normal way. Excellent. Okay.
Richard Lawson, Your Honor, for Ms. Adams. There is the matter of my pro hoc, which with the hurricane last week, we had some trouble with the certification. It should have been submitted, but
it was. I haven't had time to sign it, but I'm blessing it now orally, and we'll get it written. So I look forward to hearing from you and from Mr. Kaufman.
Thank you, Your Honor.
Is there a particular way you all are dividing things up? Every other sentence?
We figured it would probably be a hot bench, but we hadn't necessarily divided by topic. The
Okay.
original plan was for Mr. Lawson to do the opening remarks, and then I would do any rebuttal, but
Okay, we'll keep it fluid. All right, and on behalf of the county.
Good morning again, Your Honor. My name is Joe Siegelman. I'm joined by my colleagues Sanjay Karnik and Rachel Lugay on behalf of Fulton County, Georgia, and we are joined by the chair of the Fulton County Board of Registration and Elections, Ms. Sherry Allen, who's seated in the first
She's
row.
back.
I'm back.
Excellent. How did it go with the veterans?
The clinic is still going in. It's a veterans clinic, a voluntary veterans clinic, and so I helped organize the clinic for the Warrior Alliance. It's still going on, but I told him I'd be back after this.
All right, we'll get you back there soon. Thank you for being here. And thank you, Mr. Siegelman et al. And how about on behalf of the parties? You again?
Ben Thorpe on behalf of TPG, I will almost certainly be retired.
Did you get that on the record?
Almost.
Good. All right.
Good morning again, Your Honor, Daniel Holshock, Democratic District.
Good morning. You were short and sweet, so if you need to talk more, that's fine. Thorpe and Volchak. Got it. All right. I'm gonna ask the same questions that I asked at the outset of the Abhiraman matter. And I'll start with Mr. Lawson, Mr. Kaufman. Is there any disagreement from your client side that certification of the November 5th, 2024 election is mandatory?
No, Your Honor.
And that the deadline to do so is 5 p.m. on November 12th of this year?
Technically, no. I do think it's actually the 11th. Technically, yes. I think it's the Monday afterwards at 5, or is it?
It's a holiday on Monday.
Oh.
Well,
So it will be the 12th. So then, no, Your Honor, there is no objection.
Okay, all right. I had taken the 12th as the magic date, but whatever that date is, we're agreeing it's mandatory.
Correct.
Got it. Okay. And I'm assuming, Mr. Siegelman, you don't take a different view on that.
Correct, Your Honor. We believe certification is certainly mandatory by 5 p.m. on the 12th.
Okay, great. Then I think our discussion is healthily cabined to, is the work of superintendents ministerial or discretionary as they lead up to their ultimate role of certifying the elections? And I will turn then to Mr. Lawson for you to share with me what you want in your opening remarks.
Sure. So one of the key things that we try to make in our brief is that there is a great deal of authority vested by the legislature to superintendents to look for mistakes, errors, and fraud. One of the issues that we have tried to paint in our briefing is that the history and structure in Georgia has created some issues between the formerly individual probate judge or ordinary judge being the superintendent and then boards. I think a lot of the complexity that has come up and the issues currently before the court come from how a multi-member bipartisan board is to execute duties that had been envisioned by the legislature by an individual. The issue of hitting that mandatory deadline of certification is very easily done minutes before that deadline by one individual. It becomes much more difficult. I hazard a guess that the primary difference in opinion between the parties is that we are of the opinion that the operations of the board have to be moved to accommodate that deadline. Everything needs to be sped up, access needs to be provided, and in order to hit that deadline. There is one other point, which I think I should probably reference. I think the court alluded to it in the Abhiraman, if I'm getting that right, case, where the court mentioned that there was at least one jurisdiction where I think the court resides, where a member did not vote to do this. And so let me just kind of grab that issue, because if I don't, I'm sure the court will. There are two questions to bear in mind when approaching that issue of what is to happen when a member of the BRE, if I can use that, votes no or abstains. The first question is, what is the vote on? What is the pool of returns being examined for certification? The next issue is, who is actually the superintendent that is casting the vote, that's making the decision? Taking that last issue first, I think it would be our position that individual BRE members can vote no and be consistent with the manner of hitting the deadline. If with the authorities, for example, the oath that individual BRE members have to take, and we reference this. I don't have any PowerPoint for you. I find them distracting, and I'm old, so you can find it if you got a hard copy or a digital copy of our brief. I'll be able to reference where you can find it there. But if you look at the top of page 10 of our brief, and I'm referencing OCGA 21-270 sub 15. This is the oath for the BRE members. And there were some very late last minute additions and modifications to some proposed joint stipulations. But I do believe I have it correct that everybody has stipulated.
Oh, yeah, I should have done this. I'm sorry to interrupt you, but I did it in the other matter, and I should do the same. I think everyone has agreed that all the exhibits are admissible for the purposes of this hearing and whatever ruling is going to flow from it. Is that a fair statement from petitioner or plaintiff's side?
Correct. We have no objection to defendant or defendant interveners exhibits.
Okay. And Mr. Siegelman, how about reciprocity?
Yes, Your Honor, with one limitation. We were presented with a document just before we started back up here, and there may be a question about that particular document. The ones that were provided in advance, we have no problem with their admissibility. And just for one point of housekeeping, I'm not sure if there was an outstanding housekeeping issue for the preceding matter, or if now is an appropriate time to possibly address that.
What would that be?
I think the question, Your Honor, is just whether documents that we've agreed are admitted are in fact admitted.
They were. I meant to say that. I thought I did, but if I didn't, they were all admitted, because I know we had that discussion about how to get those admitted documents to the court reporter, which I hope you dealt with over the break. And I just want to do that same omnibus universal admission of all documents in the Adams case, with the caveat that there may have been a late disclosed document that frankly the defendants are still digesting. And so it may be there's no objection, but co-counsel is poring over that last minute document.
Yes, correct, Your Honor. There may not be an issue with that document. We're just reserving judgment for now.
Okay. Mr. Kaufman.
The only other clarification, Your Honor, is that there is a joint stipulation that we've sent in that we all agree on in purposes of the Adams case. We've sent it to your staff attorney as well as the court reporter. We just want to make sure that that's understood by the court and part of the record as well.
Got it. And that stipulation is in a nutshell, or is it not nutshellable?
It's really just the sort of the facts that got us here.
Okay.
It's 6 or 7.
Got it. Meaning the issues that your client encountered in the PPP, as we've been calling it.
In the presidential preference and the primary, so and how we're here at this actual controversy.
Okay.
And I can just shed some light, I think, on the issue which on the one exhibit. We're under the belief it was part of the county's production as part of a minutes, and it's really just the certification of returns from there. And I did just ask Mr. Siegelman, so and he said he would look at it.
Got it. And I'm gonna give him time to look at it, but what you're highlighting is it may be that you handed to him something he originally handed to you, and you're just wanting to highlight that as one of your submissions.
I was under the mistaken belief that it would have been included in the overall minutes that were provided on the vote day.
Yeah.
And it's just a copy of the certification of what the board members would have signed that
Okay.
day.
All right, got it. Sorry for the interruption, but helpful to know all exhibits are admitted from both hearings. With one caveat, we'll see about these certifications. I suspect they won't be an issue. Press on.
All right, so to go to the joint stip that was submitted, the second one includes the text of the oath that all BRE members will execute upon taking their seat as a member of the board. And this really is sort of a touchstone for our approach to the matter. It vests and charges these BRE members with preventing fraud, deceit, and abuse. That is the magic language. I suspect the court maybe got exhausted with the repetition in our briefing on that, but that is the goal here. And it requires them to make a true and perfect return of such primaries and elections and execute these duties, quote, in accordance with Georgia laws to the best of my judgment and ability. Of course, I'm reading my from the quote. So this is all very easily done, hitting that mandatory deadline when you have one individual doing it. But there are really kind of two steps in the process that happen when you have a board doing this. What is the slate of returns to be ruled upon for certification? And then what is the certification vote?
Why is it a question? What is the slate of? How did you just describe
Slate of returns to be certified.
Right.
That's the language.
Okay, the slate of returns to be certified. Why is that not an issue for a single superintendent, but it could be an issue for a board? The slate is the slate is the slate.
The determination of what the slate is logistically easier for the individual, logistically more complicated for the board.
How so?
In this particular instance, and this is in some of our.
Let me ask it differently, because I'm not familiar with what work goes into determining the slate. Are you saying it's easier when you have a lone superintendent because she does it and she's happy with her work, but with let's say a 5-member board, each of the 5 does it individually, or the rules are, well, you get 1/5 and I get 1/5, and then we combine them all? Because if each does it individually, you're just doing the same thing 5 times, but it should be no more difficult than it is for the lone superintendent. Query why you'd have 5 people doing the same thing, but people have created boards.
The difficulty, I think, comes in the agreement as to what are the proper slate of returns to be looking at. For example, there was some discussion.
Why wouldn't it be all?
Because there was some discussion in the Abhiraman case on the issue of you have more ballots coming in from a precinct where people who showed up. Maybe one board member has figured out that they are charged with investigating the discrepancy. Maybe one board member has been satisfied that the discrepancy has been met. The other has not.
So your example is there's a precinct and it shows that 900 people voted, but there are 903 ballots that are returned.
Something along those lines.
That ought to set off a little alarm bell. And your scenario is one of the board members said, all right, I understand why that happened. And another says, I'm not satisfied with that explanation.
Correct.
Okay.
And the individual superintendent
is either satisfied or not satisfied.
And it's clearly laid out, it's specified, he sets it aside or accepts it, whichever. And then he certifies, and it is all there for such wonderful challenges that hopefully the court won't see in November. But it's clearly identified. So with the board, you have to go through that first step of, okay, here is this slate of returns to look at. If there isn't agreement, if a board member feels like, I am not satisfied to the degree I have taken this oath, and the statute mandates that I am to investigate and look into this, I am not satisfied, I vote no. I don't view that as about just.
But why the vote no as opposed to the, as I said in the previous hearing, the certification dubitante? I got to certify. I must. There's not an option of not certifying. And so the McBurney's certification is gold star and the Lawson certification is gold star. The Adams one is, I'm not even putting a star on it. I have to certify, but see this. There was a problem with this precinct. And how do we have 904 ballots when 900 people voted? I just don't know how the certification process works. So this is an educational opportunity. Is there a single certification and it's got 5 signatures, or are there 5 certifications so that each individual superintendent, if you will, can put her own spin on it? Okay, straight up certification, concurrence with reservation. I need to understand how that works, because if it is the scenario where each superintendent, each member of the board does her own certification, then no is not an option. First of all, I don't think no is an option, but no even more so wouldn't be an option, because you could highlight your concerns. I appreciate my colleague is satisfied by this half-baked investigation that was done at precinct 9. It's ridiculous, 910 ballots, 800 voters. How do you get there? I'm going to go to the DA with it, all those things, and you can put it in your part of the certification.
So I think if you go to 493, I believe it is K. And I believe it's the last sentence. This will help explain also my confusion of the 11th or the 12th. It says such returns shall be certified by the superintendent not later than 5 p.m. and so on. So this is why when I just kind of grabbed onto this issue, I said one of the questions is what's the slate of returns? The other is who's certifying? You've said I certify in the example you were just giving. You are not. Ms. Adams, the other board members are not. It is the superintendent, which here collectively is the board in toto. That is the entity which has that 5 p.m. deadline. And so that is why our position is that a board member can vote no. Let's take the hypothetical that the court has already been well ahead of on this issue. It's 4:30 p.m. on either Monday, the 11th or the 12th. We'll just say it's the 12th and everybody will be grateful for the extra day. It's 4:30 p.m. on the 12th. One person is going to vote no. They get 2 other people. Now we have a majority of the board who are voting no. You can still hit that certification deadline if presumably those 3 would at least have a pool, a smaller pool, presumably, of election returns that they would be able to certify in time. So, a very practical issue for the court to be worried about is if it gives the relief we're looking for that a individual member can vote no, are you opening the door to missing the deadline? I would submit you're not, and you are allowing, very importantly, because in
so let me just play back what I think I heard you say. You continue to say a board member who is a co-superintendent, even though it says shall certify, can say no, but what ultimately would get certified by 5 p.m. would be a subset of all the returns. And so what would be sent to the Secretary of State would be if Fulton County is divided into 92 precincts, it might be that 90 precincts get sent to the Secretary of State and there are 2 whose votes don't count.
There would be now we have returned to a situation identical to the individual superintendent. If we go look at if any error or fraud is discovered, the superintendent shall compute and certify the votes justly, regardless of any fraudulent or erroneous returns presented to him or her, and report the facts to the district attorney.
Right, but doesn't I say you still have to do it. Like, hey, this something was wrong in this precinct. It doesn't make sense. I still have to compute it, and here's how you compute it. You look at the returns and this and that, but you flagged it. It doesn't say don't compute it.
It says compute them justly. I would
Okay.
think that that would give the authority to the superintendent if they find 50 ballots all round up with a rubber band shoved in at the same time, that superintendent could set aside, not count, because I'm exercising my discretion to vote, compute justly. I'm hitting the deadline. Mr. District Attorney, here's
You're
what I
ignoring
want.
the next phrase in I, regardless of the fraudulent or erroneous returns. In other words, calculate it correctly, not justly as in the Justice League and what would Superman do with Lex Luthor, but hey, you've identified fraud. You still have to do the math. And the math is that there were 94 votes for one guy and 84 votes for the other guy. And I'm going to transmit that. I'm also going to go to the DA's office because I've identified that there's fraud, but I still have to do the math.
Oh, I absolutely agree that you've got to do the math. I disagree with the court. I think that phrase justly, the word justly, it modifies that next phrase, that the word justly incorporates that.
Okay.
If you look at what the BRE members have been charged with, we lay out on page 9 of our trial brief a host of statutes, mostly through 21-270 and then through 493, laying out all the you shall initiate recounts, you shall look for discrepancies, you'll set aside and sequester discrepancies, all of these languages. Even in K, it states, as the returns from each precinct, this is the very beginning of K, are read, computed, and found to be correct or corrected. What I'm talking about is the situation where we can't correct or correct it before that deadline. What do you do? This is only talking about certification of correct or corrected ballots and returns. You can still hit that deadline. You can compute it justly. And here's one other point that I think is really important is there's a huge historical reference of the very limited role of superintendents in the early 20th century. And then there is the evolution to the boards. If this was truly ministerial, if this was a computation, if this is a marriage clerk receiving in these ballots, okay, I got 50 rubber bands or 50 ballots with one rubber band. I got to count it, Mr. DA, take a look at this. There's no need for a board. If there is a mandatory yes vote from board members on whatever slate of ballots is presented to the BRE, from whomever and however determined, then what is the point of a board? And this is a point of sympathy for the court on this issue. I have wrestled with this for some months now. I don't think you're going to get a straight, complete answer from these statutes. I think that this blending of a board structure on an unharmonized individual structure just creates this issue. And I fear that the task for the court is to do the least amount of harm to the fewest number of statutes, the greatest harmony here. And so we are, I guess this is a long-winded way of saying that whichever way you come down, there's going to be reasonable ways the other way. But this is part of our larger goal that we're trying to put across is we can hit that deadline. We can fulfill these mandates to use discretion to count justly, correct and correct it, investigate mistakes and errors, do all of this, and we can still hit that deadline where you're not, an order in our favor does not open the door to hostage taking or anything like that for any certification returns.
So the two prayers for relief in your complaint are: one, declare that the board members' duties are discretionary, not mandatory. And two, that board members should have full access to election materials.
Correct.
Now, you have very successfully pulled me down an intriguing rabbit hole about, well, maybe you could certify some of the votes, but not all of the votes. But we've strayed from the relief you're seeking. And I want to bend back to that. And I will tell you up front so people can prioritize their comments. I don't think the request number 2 is a particularly provocative one. And I think the examination rule actually fixes it? The answer would be see examination rule. It's the former, discretionary versus mandatory. And maybe you've taken me where we have to go, because it seems to me, given that everyone has agreed that certification is mandatory, it really doesn't matter what we call the role of the board members, discretionary or or ministerial, because the outcome in the end is certification. And clearly, board members are empowered to do a lot of searching and digging just in the statute. And the reasonable inquiry rule amplifies that. So I want us to stay on track, and for you to articulate why it is that your client operates under a veil of uncertainty, because we're not in the APA, we're in good old heartland of DEC actions. And so why it really matters if we apply the label discretionary or ministerial to the work that must be done to certify, in light of the fact that with the examination rule, woe unto election director who says you can't have this document.
Just very briefly, as to our point regarding access to the data, agree regarding the rule. And also, as I was mentioning to council, and hopefully I'll be clear here and less confusing when I was discussing with council, the point about access to data is downstream of the ultimate resolution of discretionary. If this is ministerial, just, okay, here we're taking to paper and punching it. If it's discretionary, we need access to this information.
Well, now's the time to talk about trees then. If in the end, I were to classify certification as a ministerial function, because you have to do it, in the end, you must certify. In the end, you must cut down that tree. But boy, you could cut it down with an axe. You could cut it down with a chainsaw. You could take the top limbs off first. You could just be, let's hit it from the base and hope it doesn't fall and hit a house. You can cut that tree. You could use a laser and burn it down. You have full discretion is how you cut that tree down, in the same way that you can certify by looking at lots of records or a few records, interrogating poll workers, not interrogating poll workers, looking at everything to your heart's content within the narrow window of time that you have. That's what I think we're wrestling with.
Again, earlier colloquy we had going back and forth, there was you said I need to certify, so I will return to the pronouns here. You said you certify. I would direct that is the duty of the board in toto. So to tie into the next question as to, I guess, it's a variation on the theme of what's it to us, in our seventh point in the stipulated facts, after the no vote that my client cast for certification of the presidential preference primary, the Democratic Party of Georgia sent a letter to the board, which was received by Ms. Adams, suggesting that the duty is ministerial and must be voting yes. And that's the issue, is when it comes to the election in a few weeks, if she sees things that violate her duties as laid out in pages 9 and 10 of our trial brief, of all those various issues as they relate to her oath, if she sees things that says, if I vote yes, I am not in harmony with my oath, we have a conflict. The letter suggested that the no vote would be subject to mandamus, even hinted at the potential for criminal liability for failure to do it. So there is a live issue of what should she be doing? Sure. And does she have to vote no or vote yes and going out? And this is where I go back to the idea of doing the least amount of harm to the fewest number of statutes in harmony with the overall goal. If this is purely ministerial, you don't need a board. If it is designed to have,
you don't need one. I agree, and I struggle with that. My first question originally, when I was first reading through these, was for Mr. Siegelman. Why do we have a board if this is ministerial? Why would you make 5 people check the same box. I mean, maybe the community feels more comfortable because 5 people all checked the only box on the piece of paper, which is certify. There's no other option. Why not just have one person do that? Query, why have anyone do it if all you're doing is checking a box? But it's more to it than that. I don't mean to in any way minimize the work that goes into certification. But having a board and then saying, but it's ministerial, those don't necessarily align well. But I don't know that, I'm not aware of any law or rule of nature that says you can't have a ministerial function for a board. It's just peculiar, but we do peculiar things all the time.
I think it would, its particular relevance, at least from our position, is it gives color and meaning to some of the words we've already hopped on or we've stressed in our briefings and arguments today. For example, it gives color to what does it mean to look for it justly? What does it mean for correct or corrected? When you look at all of these charges, which I believe still some counties are single superintendents.
Many.
Yeah. When you look at this mandate for investigations, it's powerful. A board checks that power. So I think that would be my theory of why you would do this. I don't think the 5 p.m. On the 12th issue changes that as far as the execution of those duties. And I do think that a no vote just has to be permitted without threat of mandamus, without suggestion of potential failure to honor legal duties. It has to be permitted to give life to these issues. And if that one dissenter brings 2 other with them, you can still hit the deadline if you move quick enough. And you clearly itemize what you have, what you don't like, you forward to district attorneys as appropriate. The parties, the candidates jump in with the litigation. It's all clear and you've hit the deadline. So, okay. Let me have, if I may have a moment, Your Honor?
Yes.
There's no reason to keep it no, and then keep until you think greater yes. There's no reason to eliminate. I think you can show them certificate.
So it might be worthwhile just briefly to talk about the stipulated facts that the parties have entered into. That is the ultimate basis of this trial, as it clears that up. So Ms. Adams did get onto the board earlier this year. She took the oath as it was.
So we're clear for the record, Ms. Adams is seated here in court. Thank you for being here, Ms. Adams. But I just want everyone to understand who it is sitting next to Mr. Kaufman on the other side.
And I will try to stick as closely as we can to the stipulated facts because there's various issues associated with it. But earlier this year, before the presidential primary preference, there was a request for additional data that Ms. Adams made to staff for the Fulton County BRE. That data was limited production, very, very limited production was made then. Uncomfortable with the production, she voted against certification. And the later primary, there was a second one in May, more information was provided, but not all.
And day of.
And that, furthermore, that information was provided day of with limited time to review. And so as a result of that, she abstained. And the last point in the stipulation is the letter we discussed. So another point to review, and I think I believe it's the county and their pleadings sort of do the chronological breakout of how much time it would take for individuals to view here.
Right.
The statute does allow for staff and for a bureaucracy to come in. And in a county of this size, of course, you're going to need it. So one other point that's just desperately important here is Ms. Adams is not only involved with casting certification votes, not only charged with looking at the returns between the vote and the certification, there's a managerial hat here of, hey, what didn't work this last election? How do we make this work? How do we process all of that? So I invite the court, when it looks at that flow chart, and I'll take the county's word for it as to the man hours and time involved with all of that, that the solution isn't adding more BRE members. The solution is giving BRE members, this is part 2 of our claim, and perhaps solved by the new SEB rule, more power to look at the data and determine, okay, how many staff do we need to make sure we're catching these things so that the problems with the returns, so they can be found to be correct or corrected, are getting to the BR members in time. And again, one of our key points here is that deadline is there. It's staring everybody in the face. The BRE has to accommodate to it. Administratively and decision-making points, fabulously easier under the individual situation. For the reasons we've been discussing here, it is just more complicated with the board. But again, I think the biggest issue that we have here is the biggest guidance that could come from the court's order is that she would have the confidence to be able to vote her conscience, vote the way that she thinks is honest to the statute, honest to her oath, and honest to the board, and not be in trouble. And I think yes, sir.
So discretionary, as you're using the term, would be the discretion to not certify either everything if there is a good faith belief that nothing was right, that maybe there was a systematic infirmity, the Dominion machines. Don't sue me, I'm making it up. It's a fictional reference. But if there's a systematic infirmity, I can't certify anything. Or your scenario was, hey, there was something real strange with these 2 precincts. I'm going to certify everything else. You have my yes as one of 5 members, but I'm not certifying these. That's the discretion that's the extent, the full reach of the discretion. It would be really, certification is not mandatory, it's discretionary. Even though it's you shall certify, it's you shall if you can satisfy your oath.
Well, I hope I'm answering the court in this, and I don't mean to be, I've come to this a couple of times. I think it is very important to be clear as to who is certifying. The BRE has that duty. I think she is wearing a hat as a board member. If we should get to this in a second, but if
each of the board members ought to have the same obligation. And so if a board member could not certify for all the good reasons you've described, then there could be no certification. It could be because we all agree those Dominion machines, boy, they didn't work. And so we're not certifying. That doesn't seem to be an option, not certifying. Yet if an individual board member has the discretion not to certify, you are creating a situation where the board doesn't have to certify, and thus the superintendent doesn't have to certify. That seems to be in conflict with the law, not in harmony with the law. That would be a problematic ruling, I think, from me to say discretion encompasses the ability of a board member to decline to certify some or all of the votes. But don't worry, because I'm only one of a group, and it's really the superintendent who certifies, which is all of us. But it wouldn't be just Ms. Adams, it would be every member of that board who'd have that same right. And you could very easily have an outcome where there's no certification. How is that consistent with the law?
Because I think the court is suggesting there has to be a mandatory yes vote, but it begs the question of yes vote on what? What are we certifying?
So I'm not saying yes or no. I'm just reading back to you, shall certify. You can call it a yes. I'm calling it certifying. If it's not certified, maybe that's a maybe vote. Maybe that's a not today vote, but it's not certified. And you have failed to meet your legislative mandate. And I'm hard pressed to subscribe to a degree of discretion that would empower the superintendent, which is composed in this county and many others of multiple people. It would empower superintendent not to certify. I don't think the superintendent has that discretion to not certify. Let's stay away from yes and no, to not certify. You shall certify.
You'll certify to the degree you're certifying just as ballots and returns that are correct or have been corrected and have been computed justly. That pool shall be certified. What that pool is has to be determined by 3 votes. The board by statute can only operate by vote. I'm not suggesting for a moment that the board or the board members can ignore that duty to do that by that time.
Okay.
But I am suggesting that you could vote no as a board member and be consistent. And if 3 vote no, practically, we're going to assume that there is some subset of justly computed votes of corrected or correctable returns that hits the definition with a clear identification by the superintendent writ large. These are suspect.
Got it. So the certification under your view of discretion could be from any number of counties. We are certifying 40% of the votes or 60% of the votes or whatever. And it doesn't matter the percentage, less than all. It's creating this new form of certification. It's a partial cert. I guess each vote that meets the criteria is fully certified, grade A certified, but there would be a category of votes that would be not certified in any number of counties.
And I think that's been the law in Georgia since the expansion of efforts to superintendents back in the 60s. And certainly
you have a specific example, because my read, and I'm the novice here, so it is okay to be very, very, Judge, I'm gonna have to talk down to you on this. That's fine. You're not talking down, you're educating me. I'm curious if there's been a situation where certification has been, we're certifying 75% of the votes, these other 25% were not, as opposed to the way I read the law, which is, hey, we're certifying everything. There's some problems with some of these votes. Go have yourself an election contest.
Okay. I don't have a historic example. If the
Pause. Any historic example from anyone on the defendant side of that scenario where certification is of less than everything?
Your Honor,
Your Honor, I do believe we have some case law where that happened nearly 100 years ago, and that's when the Supreme Court stepped in, and I could find the exact language and a description of that case. But my understanding is the one time that happened in Georgia's history, the Supreme Court stepped in and said, no, the duty to certify is in fact ministerial, that all votes must be counted.
Okay, and that's one of the older cases that I appreciate you're distinguishing, Mr. Lawson, because the role and the nature of superintendent has F4S, there's much more to it. So I appreciate it's distinguishable in some respects, but it's particularly pertinent from the perspective of there's no partials. You certify. You can certify with all sorts of concerns, but thou shalt certify. You're helping me understand a different perspective. I just wanted to make sure I was properly digesting the full thrust of my role is discretionary, not ministerial claim that you're making. And I feel that I do.
Okay.
I also want to be mindful of time.
Yes,
we've gone around on this for a while, but I feel like I've got a handle on it. And so I don't want to preclude, Mr. Kaufman might not buy you coffee next time if he doesn't get to say anything.
Well, maybe I'll just end on this one note.
Yeah.
I think a result contrary to what we are hoping. I fear it may force her to be in a position to have to vote yes when she feels she's violating her oath. That's our really core issue.
No, and I get that. And you're the first, I mean, it was in your pleadings, but the oath has always been over here. And we kind of treat these oaths as, yeah, I got to get through this. I hope don't misspeak while I'm being sworn in for the first time. Oaths have meaning and they have a purpose. Otherwise, we wouldn't have people subscribe to them. And so it's very important to see how that juxtaposes with what you got to say yes. And if there's impossible tension there, something has to give. It's not going to be the oath. So, all right, Mr. Kaufman.
Your Honor, just maybe quickly, and I think you're spot on the oath, and that governs your entire tenure as being a member of the board and all your responsibilities. Also, the election code defines an election as the entire process. So part of that is having access and meaningful access, because if the board member has meaningful access, and, we've heard a whole lot of talk primarily in the prior case about, oh, it's a huge burden. I mean, most of these things are digital. It's just an extra password. It's, just being kept in the loop. If you have meaningful access throughout the process, you're certainly more enabled to certify.
You don't need to spend a lot of time on that because I agree that more is better, and I'm gonna need to be educated by the county how it would be that anyone associated with elections could say no to a board member, an extension of the superintendent, asking for information.
Thank you, Your Honor. And so the only other sort of high point is how a board works. And is it, when do you vote no? Right? I mean, there's no reason that a board can't vote no, I don't agree, as they've just been handed to me by the administrator. I'm willing to vote get to an ultimate yes. But I mean, boards do that all the time. We take preliminary votes. But the idea that you have to come in at 4:30 p.m., having basically a county with over 1 million people, and you had 4 or 5 hours to do your job, places you in an impossible position. And that's the problem. So that's partly why, the board, the state election board did what they did. The other thing, and this is the exhibit that we haven't reached agreement, but
what you made a reference with which
the state election board for the reasonable access. And I would argue that that's discretionary in the board member of what reasonable access do I need in order to fulfill my job. And that's part of discretion versus a ministerial component in my
Sure. And I want to be clear, by nothing I'm saying, do I mean to suggest that even if in the end, the determination is the process of certification is ministerial in nature, that it doesn't involve a ton of discretion, access to information, meaningful review of that information, et cetera. To me, those are separate. And in some ways, I think people are demanding that a label be put on that role. Is it discretionary or is it ministerial? In the end, if the role of certifying is deemed ministerial, it doesn't strip away the need for an access rule, more time, maybe more resources, so that there's more informed judgment going into what goes on. If the framework ultimately that is, you have to say yes, but it can be with the following reservations. How meaningful is that right to have reservations if it can't be informed? If you get everything at 4:30 and you have to certify by 5, you don't have a chance to poke around in areas that seem like, as a superintendent, a co-superintendent, you're entitled to poke around in. So you don't need to spend a lot of time on Ms. Adams should have more access to information.
Yes, I think and I appreciate that. I think the issue is the issue of discretion on what do we ultimately certify? What do we agree to? And I think it's very important, and, I respect Fulton County's position that this is their form. It's got the state seal. I'd argue it's admissible.
Is this the exhibit?
This is the exhibit at issue.
Okay. Is it okay if we look at it? It looks like it's a blank form.
It's just a blank.
Yes, Your Honor, this was not anything that we had previously or had provided and then decided not to use. It's not anything like that. This is just something that in the course of our work and with the chair here who's new, that we just aren't familiar with this document and therefore aren't in a position to authenticate ourselves or stipulate its authenticity. We have reason to believe, in the same as plaintiff's counsel, that it probably is what it purports to be. But just
so what I'm going to do is accept it as what was likely the certification of returns. It's not all that long ago. How new is our director of elections?
August.
Okay, this predates you by many months, so this is not on you, but it's not all that old. And if it comes to light that this is a forgery or a fraud, let me know. I'm just curious. It's very helpful to see what is the certificate. I figured it'd have a gold seal on it.
Well, it's got the state seal on top,
That's
but
not
it's
gold.
not shiny.
Oh, yeah.
We'll talk to the secretary, and I'll proffer at the bottom, Your Honor. It says it's, I believe it's a form made by the Secretary of State, and they claim it's pursuant to OCGA 21-2-493.
Yep.
And significantly, we talked, going back to my colleague's position, about all the things that have been added on to the responsibilities of a board of election as part of that exact statute.
Can you zoom out a little bit on the form? Okay.
Yeah.
And if you ask me to call it out and stuff, you're pushing my
No, this is good. Just leave it like this.
But the point is, all those rules were placed really in 21-493, most of which were added in from 2001 to 2021. And the point, and that goes back to I think the original question of what's the point of putting 5 people on the board when you had 1? The point is that I believe is that they were going to take on greater duties and responsibilities in order to give the public at large more confidence in the election outcomes.
Do you have an idea? This form, it looks like the members of the board would sign where there's 6 blanks, and yet confusingly at the bottom, there is an attestation from the superintendent. Does that get into this tension we've had in Fulton County where they delegate to the director of elections, kind of you're the superintendent, but we're the board? And so that's who that, or do all 5 people sign real small on that line that says superintendent?
I believe the board members sign above, and the who I would call the administrator, the hired person, would sign as that supervisor of elections role. But that is that issue. But for purposes of here, I think it's important when we start getting into discretion and how a board acts. And again, going back to our concept that the board should be able to, you could vote no the first time. I can't certify as it's handed to me by the administrator, but let's work it out as a board. What can we agree on? What can we not agree on? What do I? And that's exactly, frankly, what Ms. Adams tried to do. She actually tried to say, look, can I talk? Can I share my concerns? There's some specific precincts. No. It's an up or down vote. And I think that's where we're getting into this idea of a board chair saying, this is how it is. It's not discretionary. Take it or leave it as it's given to you by an employee. And that's what usurps the authority and the ability which the legislature gave to the board. And candidly, an employee can't take, or even if it has been assigned or delegated is the word, all the responsibility away from what the legislature gave. And that's where we're needing some help from the court, I believe.
All right, I don't know how, see if, it should be working now. I don't know. I don't know how we check. Thanks. It is working now. Excellent. So I heard everything you said. Your fan base in Omaha, Mr. Siegelman, may not have heard the last few things you said, but I'm sure someone will catch them up to speed. So you were talking about how some of the materials take a while to produce, and so it's not just, and concern about secrecy of ballots, that maybe we've hit that kind of HIPAA point that I was thinking of sure, you get a lot of information, but then there are certain things you don't get. Not that there's medical information on a ballot, but those are typically things that no one sees.
Well, and Your Honor, I think there are, yes, agreed. There are a lot of unanswered questions that I don't know that we need to answer today. I'm happy to pose those questions, but I mean, one would be the mandatory timing of disclosure of any documents. Another would be the means of disclosure of the documents. There's code sections that require a custodian to be present on the review, and so are board members permitted to take home and distribute sensitive documents? Must they review them themselves? Must they, can they publish them on, a website or social media? And so protection of the information, obviously what is subsumed in the disclosures. And we have an exhibit that's being introduced where there is a trove of election documents that's being provided or has been provided, and I presume would continue to be provided in future elections to Board Member Adams and other board members. But when even that isn't enough to satisfy the quote unquote discretion that Board Member Adams claims that she has, and again, I'm framing it that way because that's how they framed it in this litigation, then there's a real problem when you provide a whole lot of data that should satisfy, a reasonable inquiry if we were to go there.
Okay, so your point is not that the answer would often be no, you can't have things. It is yes with qualifications that are consistent with privacy, ballot security, the things that one would naturally be worried about if you're saying, well, here are all the ballots from this precinct. You can't leave the room with them. These are the originals. And maybe you can't even have copies because this is sensitive material. And so you'd have to review it in a certain way within the incredibly narrow time frame that they're operating.
There is no statutory duty that is cited by Ms. Adams that entitles her to the documents that Fulton County has voluntarily supplied as a courtesy. Maybe that changes with regard to this examination rule or even the reasonable inquiry rule. But the basis for receiving those documents is based on the discretionary belief with regard to certification that plaintiff has. The county as an attempt, because we have nothing against Board Member Adams.
No, but let me push back a little bit on that. I know you're having to say the county because that's who you represent, but every member of the board is a part of the superintendent, and that's the boss of the elections. What would the basis of a no answer be other than the statute says you can't have it? And that might maybe just be the ballots, but for everything else, you're making it sound like, hey, we don't have to do this, but we're being nice to people. Forget about being nice. What would the basis be to say no to any board member, part of the superintendent elections? You can't have this election-related material.
Well, I think we would refer the court to the statutes, which would be, in this case, it would be 21-493, and you'd say subsections, I think it's B and C, and this is the limited discretion that board members admittedly do have, but it talks about if essentially the hypothetical that Your Honor has already presented, whereas if the numbers don't match for whatever reason, then there is an opportunity prescribed under the law to get documents to get to the bottom of that issue. What we're talking about here is when there's not been a prerequisite satisfied. So your question is sort of twofold. Does the county have a problem providing the documents? They don't. They already have. That's in their practice. But legally, are they entitled to them is another question. And according to the law, again, without these additional rules, which probably weren't passed but for to create that legal obligation. The law doesn't necessarily prescribe that the superintendent's entitled to this every document from every precinct,
Okay.
even when there's no tabulation issue or error.
Right, and you're right, we did work through that some with the previous hearing, but it sounds like you're also acknowledging that the examination rule, should it withstand scrutiny, would be something to which a board member could point in making a request that would obligate the county, whatever that means. It sounds like it might be part of the superstructure over which the board sits anyway. So it's sort of like the CEO reaching down to a regional manager saying, hey, I want some stuff, and the regional manager saying, you don't need it. I don't know that would go real well.
The short answer is twofold. First, with respect, it's not an issue in this litigation, so it's not one that I necessarily am prepared to address, at least in sufficient detail for your honor. But I think the county would have a problem with it for a couple reasons. One is that there's a timeline required. I think it's 3 p.m. the Friday before. Some of these documents may or may not be ready in time, or it may take away from other important work that a limited staff with a whole lot to do has to deal with. So I would suspect that there would be an issue there. There is a mandatory responsibility. And also, there doesn't appear to be a limitation into what all election materials, because that doesn't seem to be defined either.
Yeah.
The plaintiff here is asking for the ballots, unsealing of ballots, which I don't think is allowed under Georgia law. So, yeah, and then on top of that, there are all the other questions of, well, what are they entitled to when? How are they able to receive it? And I think that there's a score of unanswered questions in that uncertainty that is going to be problematic, especially when staff is already working tirelessly to conduct the elections.
Okay. I think I follow you. It sounds like it's more of a resource limitation than a shouldn't have access to them apart from the ballots.
Depending on what they are.
Right.
Yes. And how the method of obtaining them or disclosure. Yes.
Okay.
And again, the county is already providing those documents to Board Member Adams and the other board members. So I have a number of other issues to go over with your honor. I'm sort of going to go and we've bounced around. I'm not going to go in any particular order. The first is just, I want to be sure that I asserted, and this is included in our brief, but we believe there's still a tangential sovereign immunity issue here. And in particular, we believe that this matter is in fact barred by res judicata.
Okay, you don't need to spend time on that. I read that.
Okay. And I want a little bit about boards. The boards of elections in the state do a whole host of work. It is not just the certification of elections. And this case law, I mentioned the case earlier when the court asked, it was Tanner v. Dean, 106 Georgia 394. This is an 1899 case. There are other cases that followed it. But it's a long line of cases that require superintendents and members to, well, in the case, I think it was superintendents, but that they're required to vote and they're required to certify that it's a ministerial task. But on where boards are, since that line of cases and since the election code has changed somewhat, the mandatory requirement of certification hasn't changed, and the duties of superintendents haven't materially changed, such that all of a sudden these cases that ruled applying to individuals that the duty to certify is ministerial and mandatory, that the change to boards doesn't undo any of that. I'm not going to go through our argument in great length on the difference between ministerial and discretionary. I think the court is already well versed, and of course our briefs go into that issue in detail, acknowledging there's another defendant in this matter and a defendant intervener. If they want to address that, we'll let them.
What is an example of something that the board does where the board format makes sense? Because I felt that counsel for Ms. Adams made a good point. How does ministerial certification being ministerial make sense with a board? Why would you create a board? And I know you didn't change this, but You alluded that the board does a whole lot of things. And so don't think that the board and ministerial don't fit as a construct, because that's just one thing the board does. And so I thought maybe you had examples of, here are these other things the board does where it makes all sorts of sense that it's a 5-headed entity rather than a 1-headed entity.
Well, you're right, Your Honor. The first thing I'd say is it doesn't matter if it makes sense to me. The legislature has prescribed boards.
Right.
There are many boards in place, and the duties of those boards hasn't changed with regard to certification. So I have to leave that. But yes, there are many other duties that they'll handle, from registration, advanced voting, absentee voting, voter challenges, list maintenance, buying voting machines, and other responsibilities. There's a lot to do. There may be opportunities such as with voter challenges where the vote of the board would make sense, and where that does in fact occur.
Where you're getting more of a cross-section than just that lone superintendent, and whoever is able to appoint the superintendent controls the outcome of all these voter challenges.
Correct, Your Honor.
Okay.
I do want to spend, without wading too far into the discretionary ministerial question, I do want to talk about the oath, because that's come up now multiple times in opposing counsel's remarks. The oath has a few points that I want to talk about. It says, I will make a true and perfect return of such primaries and elections. And that seems to be a point that Ms. Adams has come back to and gives her some trouble. Perfect return in the oath. Well, I'll keep reading before I go to the next point. That the oath is to perform her duties or any board member's duties in accordance with Georgia laws. So whatever this oath applies to is limited by the duties prescribed by Georgia law, and the duties regarding certification are statutorily enumerated and prescribed. And going back to the true and perfect return, 193. As Your Honor pointed out previously, where if error or fraud is discovered, the superintendent shall nonetheless, I'm adding nonetheless, compute and certify the votes justly, regardless of any fraudulent or erroneous returns presented to him.
Isn't adding the word nonetheless a pretty serious editorial? I mean, Mr. Lawson, like, there's no nonetheless in there. I read it the way you do, as in nonetheless is there, but that word's not in there.
Well, and I'll explain.
So don't add it.
Fair enough. Fair enough. I'll explain, why I get there, because I want to go back to this word justly. But the point is, regardless, and that preceding language is not pertinent for this, but regardless of any fraudulent or erroneous returns presented to him or her, the superintendent shall compute and certify the votes justly. My point there is that if there is discovered fraud or error, and yet the law says you certify anyway, then the law says you're certifying a necessarily imperfect return. So my point there is that if we're to reconcile these two, which I think we can and should, that limitation to duties in accordance with Georgia laws, excuse me, in accordance with Georgia laws, has to be taken into consideration, especially in light of provisions like that actually govern the duties of the board and board members. And I don't mean that as the oath is not important.
The oath is important. I don't know that you can reconcile it. And the reality is oaths are written so that they sound good when you say them slowly in bite-sized pieces and someone repeats it after you, but they're not meaningless. And there's clearly some tension between a perfect return and a statute that says, hey, even if you think there's some errors, you still need to certify it. To me, it's resolvable by having a certification that has a comment box for each of the certifiers. I know I'm certifying, but I've got concerns about precinct 17. Good. All right. Now it's on notice. And there can be an election contest about that. A district attorney can jump into action. Who knows? And that's another value of having a board, because you have board members who represent different political perspectives who can empower entities that would want to bring an electoral contest based on those concerns.
Yes, Your Honor. I'm glad you mentioned the point of even if, as we contend, board member Adams should and must certify the election, She has issued, and this is actually included in one of our stipulated, or I shouldn't say stipulated, but they agreed to admissibility on the exhibits. This is exhibit number 13, that, as I understand, has already been admitted. This is Ms. Adams.
This is your exhibit 13?
Yes.
Okay.
Correct, Your Honor. This is a certification decline statement that that Ms. Adams issued with regard to the presidential preference primary. And the point is, it's such a documentation, such a statement made in conjunction with certification is not only already contemplated, it's already occurring. The difference would be that, depending on how this court rules, if it does rule that certification is mandatory, Board Member Adams could nonetheless still issue a similar statement, but in conjunction with certifying voting to certify the election. So I bring to the court's attention that what you have mentioned now a few times is actually something that's already done, only Board Member Adams has voted not to certify in those instances.
That statement, do you have any idea, was that a statement that would have shown up on her website, or that's something that went to the Secretary of State so that his office was alerted to the concerns, or it would have gone to the relevant authorities only through osmosis and media coverage?
I don't have an answer to that. I do know that, or my understanding, I should say, is that it was made at the meeting when certification occurred, or it was presented at the meeting when the certification occurred. So it was made in conjunction with and a part of that process. To the extent it was attached to any official certification, or where it was transmitted or how, I don't have that information.
Okay.
Going back to 21-493I, which I misquoted, as the court pointed out. Going back to justly there, we include the citation in our brief, and I'm happy to find it and direct the court, but it's essentially the Black's Law Dictionary for justly, which means, according to Black's Law Dictionary, legally correct. The plaintiff in her, yes, this is 12th edition, 2004, defining just as legally correct, or legally right, excuse me, legally right. But plaintiff cites to Webster's, which has includes another definition, and we would contend that justly does mean what it states in the Black's Law Dictionary, which is what is legally right. And here, what is legally right is certifying the election results. To the extent any error or fraud is discovered, the votes are certified nonetheless. And then, as has been addressed, not to rehash any of this unnecessarily, but Ms. Adams or the board can refer matters to the district attorney, and there also, of course, can be election contests which cannot actually commence until certification occurs. So it's a disservice to addressing any potential fraud or ineligible voters, because there would be a delay to resolving that election contest if certification is delayed or doesn't occur by the statutory deadline. Going back to boards just for a minute, plaintiff's counsel has asserted that it's logistically more complicated with board members. While that may be a perception that Board Member Adams has, if the duties that are prescribed in the statute are followed as written, it's not that complicated. And if certification is mandatory, as we contend that it is, then it's a vote to certify the tabulation, and not to minimize at all the certification process and oversimplify it. It's a tabulation of the votes. It is confirming that the numbers add up. There is not, at least not contemplated in the statute, any sort of reasonable inquiry or unilateral investigation when the tabulation on its face is correct or appears correct or accurate. And that the investigation component that has been referenced, at least according to the statute, not taking into consideration any of the potential rules addressed in the other litigation, that they're premised upon that discrepancy being present. And opposing counsel likes to conflate and has in fact in their brief, and I can cite to it, they cite to discrepancies or other potential fraud. Just because a discrepancy exists, there's some numerical calculation that doesn't quite align, doesn't mean that it is fraud. And to equate discrepancy and fraud, I think is misplaced and inappropriate. And we are not minimizing that fraud could possibly occur or that it could be discovered in this process. But with regard to this litigation, again, not taking into account the rules, going back to how plaintiff herself has framed this lawsuit, to the extent the duty to certify is mandatory, then her secondary claim for documents in this sort of sweeping investigation without any discrepancy necessarily being present is dispositive of that request for documents and examination if the duty to certify is mandatory. I'm happy to answer any more questions. I think I'll look at my notes. I think I've touched on everything. If you'll give me 1 minute just to confirm with my co-counsel if there's anything we want to add at this time.
What do you?
Your Honor, briefly circling back to just some opening comments that I didn't get to because I know we jumped right into substance, which is good. Fulton County's interest in this matter, other than being a defendant and having to address it, is we want free and fair elections. We want every lawful vote that's cast to be counted, and that such votes are ultimately certified in accordance with the law.
I think that's what everyone wants. It's a strange posture we're in because really, other than with the addition of the interveners, everyone's on the same team. Fulton County, its board of registration and election. I mean, this is all county folks working towards the same goal. It's just a question of how do we get there and how do we get there consistent with the statutory scheme that's already in place, which says that certification is mandatory and it must occur by, with this upcoming election, November 12th at 5 p.m. So I'm not reading ill will or animus or anything on either side. When I pressed you a little bit, it's only been on that question of why wouldn't information be made as available as possible to the board members as they try to do their job, which is an important one. And some of your helpful pushback is certification is more akin to tabulation. It's not, let's go hunting for fraud. That is not the essence of the legislation. It may be the essence of rules that have followed the legislation, but rules don't shape legislation. Legislation shapes rules. And that's where I think we are with this. So I don't mean to cut off your opening at the end of your presentation.
No, I appreciate that, Your Honor. And I did actually want to touch on one final point, which is on the other side of the V in this case is the Democratic Party, which has intervened. And while some views of the law overlap and are consistent as far as the position that the interveners have taken and the position that Fulton County has taken, we certainly view this as a purely nonpartisan issue. The outcome of the election doesn't matter. We want the votes to count. We want certification to occur, and we want any potential fraud or discrepancies to be addressed and uncovered. The county's, the county's position is we're going to continue to work with Board Member Adams on the documents that she's requesting to get them to her in a secure and timely manner so that she has every opportunity to review what we can disclose at the appropriate time, and that will continue. And we hope, and this may be a little naive, but that she will, to the extent this court does impose the requirement, to the extent it's not already clear under the law that certification must be undertaken by Board Member Adams, that at the end of the day, no statement is needed, that she feels good about exercising that what we contend is a mandatory legal duty. So hopefully we can get there, and we appreciate the court's time and attention to this, and to the extent there are any other questions, we're happy to address them.
All right, thank you. Mr. Volcher, striding towards the podium.
Thank you. Good afternoon, Your Honor. Again, Daniel Falchuk for the Democratic National Committee. Your Honor, you asked Mr. Lawson at one point about the relief that's being sought here, and I think what's very clear from the discussions you had with plaintiff's counsel is that what's being sought here is a judicial order or approval of the notion that individual superintendents can refuse to count voters' ballots. They can make individual determinations about a ballot is fraudulent or otherwise should not be counted. Now, that is a recipe for chaos, and I want to explain why. It is also a recipe for denying Georgians their right to vote, because no one is perfect. And if you are excluding somebody's ballot on suspicion of fraud, there's a possibility you're wrong. Now, nobody is going to object. I'd be happy to. No, I would be happy to. Thank you for the reminder. If you are excluding people's ballots on suspicion of fraud, there is a risk that you are making a mistake and you are denying someone the right to vote. Now, I want to come back to that, to how Georgia's statutory structure deals with that issue and that possibility. But I want to address why the notion that individual superintendents can disregard individual ballots, and that is certify fewer than all of the ballots that were counted, is wrong under the text and the statute and the case law. And let me start with the case law, because Mr. Siegelman touched on it, but it is these Georgia Supreme Court cases that quite clearly say, so not just Tanner versus Dean, which he talked about, but Bacon versus Black and Thompson versus Talmadge. And Bacon versus Black speaks directly to this question, because the issue there was whether certain ballots could be excluded on suspicion of fraud. And the Georgia Supreme Court, and this is pages 253 to 254 of the decision, said the superintendents who consolidate the vote of a county in county elections have no right to adjudicate upon the subject of irregularity or fraud, which will permit them to examine the ballots and review the returns of district managers in order to ascertain whether they're correct. That is the holding of the Georgia Supreme Court. So that is obviously binding precedent. Now, they have arguments.
For now.
They have arguments that those cases are distinguishable because the law has changed. But it has not changed in any meaningful way. It has not changed in terms of whether the duty.
Isn't the primary claim, well, now we have boards rather than superintendents?
And that,
it's a little more than that, but there's more to the law, but they haven't pointed to, and here is a legislative enactment that says you do have a right to adjudicate on ballots.
Right, there is no such legislative enactment. Now, for sure, a number of superintendents are now multi-member boards, but that doesn't change anything, right? There is still one superintendent per county, and that one superintendent can, and we submit, and apparently everyone agrees must, certify by the statutory deadline. Now, that doesn't mean anyone is a rubber stamp. Your Honor was discussing this with some of the other counsel. Why have multi-member boards? Well, you got to the answer, I think, which is that boards have certain superintendents rather, have duties that are discretionary. And I want to come back to one very important one in just a minute. But when you have discretionary duties, having more people involved instead of a single person, more judgment to bear, hopefully you get to a better result. Another reason, it's a simpler reason, Your Honor, but one person could die just before the election, and then you don't have perhaps a superintendent in office if you had a single member superintendent, not the case with a multi-member body. My point is just the change from individual superintendents to multi-member bodies has no bearing on whether certification is mandatory and whether it includes a duty to certify all of the ballots. Now, why do I say the current statute imposes such a duty? Because there is one and only one time that the legislature has directed that a superintendent has discretion to exclude votes. It's in 21-2-493 B and C. We were talking about this scenario before, not in the context of those particular paragraphs, but it's the scenario Your Honor raised of there are 800 registered voters in the county, there are 900 votes cast according to the machines. In that circumstance, the statute directs that an investigation shall be held, and now I'm going to see here, because this is the provision that really provides the discretion. It says when you've got a paper ballot, superintendent can require the ballot box to be produced, and you recount directly out of the ballot box. And if when you do that recount, you still find that there are more ballots than there are registered voters, or more ballots than people who showed up to vote, then it says, the superintendent may, in his or her discretion, exclude the poll of that precinct. And it goes on at the end of C, either as to all elections or as to some of the elections. So the legislature has directed when a superintendent during the 6-day period that he, she, or it has to carry out the certification duty may, in his or her discretion, exclude actual votes. Their position would be, despite this, there's actually much more discretion, and you can do it almost any time you want if you suspect fraud or abuse. I submit the legislature's express granting of this authority to exclude votes in one particular circumstance implicitly excludes the authority to do it in any other circumstance. And this is not saying the superintendent must do it in that circumstance, such that the other side could say, well, but in other circumstances, it's discretionary, you still have that power. 493C says in this circumstance, you may. And it is not consistent with that provision to say that there's actually the discretion to do it in a whole bunch of other circumstances. The legislature told us the one circumstance in which this could be done. Now, I want to talk about 493K, which Mr. Lawson also talked about. This is obviously the last paragraph, or it is the last paragraph of 493. And he was referring to the first sentence, which talks about the returns being found to be correct or corrected. Okay, but there are two very important words after that he didn't say. Correct or corrected as aforesaid. What the legislature is saying there is that what the superintendent has to do is engage in all of the steps we've talked about as appropriate under the circumstances in A through J. And when you've gone through those circumstances, none of which involve making individual determinations about fraud or anything along the lines that plaintiff is suggesting she and others have the authority to do, once you've done that and found them to be correct or corrected, then you shall certify by 5 p.m. by the deadline. So it's all consistent with that. I skipped over briefly 493I, which is a provision you discussed with Mr. Siegelman about justly, right? One thing that justly we know cannot mean is not certifying and not computing at all, because as Your Honor discussed earlier, it says even when there's fraud, you shall certify, you shall compute and certify justly. So it can't mean not compute or certify at all. And our submission is it certainly cannot, whatever discretion justly might otherwise provide, it cannot provide discretion that is explicitly or implicitly withheld by other provisions of the election code, and certainly of the same section of the election code. As I just explained, 493C implicitly withholds discretion to evaluate or to exclude individual ballots, save in the circumstance that 493 identifies. Now, we talked about the oath, and I think Mr. Siegelman basically covered this, but the oath, Your Honor, says that the person taking the oath will, to the best of my ability, avoid waste, fraud, and abuse. And so that does not necessarily mean voting no or refusing to certify or certifying fewer than all of the ballots. As we were discussing, there are many ways for somebody who has concerns to raise those concerns, to raise them publicly so that any actual concerns about fraud, abuse, et cetera, are dealt with in the way the Georgia legislature provided, which is in post-certification election contests. And I talked earlier about statutory structure in addition to text and to case law. It is that part of the statutory structure that I think underscores why superintendents don't have the discretion that plaintiff is alleging. The legislature has created a very rational system that, by the way, has worked largely without incident for many elections in many counties until recently. A structure in which superintendents oversee the tallying, the counting, all the steps in 493, they certify, it then goes, if anyone wants to raise a contest, to the contest. And that, of course, is where it should be, Your Honor, because we are talking about, as I alluded to at the beginning, about the possibility of denying someone wrongfully their right to vote, or voter fraud, exceedingly rare though that is. Either of those is very serious, and either of those should be dealt with in the judicial system. Adversarial testing, presentation of evidence, everything that comes with that, and that is what the Georgia legislature has prescribed. Unless the court has questions, Your Honor,
my wrist is sore because I had to write down a lot real quickly, but no, that was very, very helpful. You said there were case law and statutory, I thought you had a trifecta reasons why
I did, Your Honor.
Yeah.
Statutory text.
Yeah.
493B and C and K and I. Statutory structure. Superintendent's count over here. Fraud is dealt with by election.
Structure.
Yeah.
Okay.
Election dealt with by the courts. The Georgia case law.
Got it. I figured you covered all three. It was
Blue fast, Your Honor.
being hit with a machine gun. But I got it. Okay. That's very helpful.
Thank you, Your
I
Honor.
appreciate it. Nothing? Okay. Then Mr. Lawson and Mr. Kaufman, either one of you, let me turn to you as the plaintiff, counsel for plaintiff, if there's anything you want to say, just wrapping things up beyond what's already in the briefing, et cetera, which has been very helpful.
Sure. I think just maybe three big points. One is we don't necessarily agree with your interpretation of an oath. That, in our view, and Ms. Adams' view, is the overarching guiding light. Same kind of thing that us attorneys here all took an oath to uphold the Constitution of the United States, Constitution of the state of Georgia. That's no different than here. And then when you read the statutory language later on, sure, it helps give greater guidance as to what that means. But I wouldn't minimize the oath, especially it also goes, I think, when you read it, there's an affirmative aspect of what they're supposed to do. To the best of my ability, I will prevent any fraud, deceit, or abuse, which is sort of, and that's an active thing that I will do. The other thing is basically every one of their cases, in our view, is wholly irrelevant. They all predate the creation of the board structure from 1978. And more importantly,
was the oath, if you know, the same for superintendents pre-creation of boards? In other words, back in the era of Tanner and Bacon and Thompson?
Well,
I assume there was an oath for the superintendent as opposed to board members.
Yeah, sure.
Just very quickly, I don't know the specific answer to the oath. I do know that the powers of those superintendents were much less statutorily.
Yeah.
Okay. So their oath probably would have been different anyway.
I would assume.
Correct. Okay.
And it appears that the section with the oath changed in 03, 08, and in 2011. And then significantly, and I think ironically, but OCGA 21-2493, which counsel for the Democratic Party spent a lot of time on, fully expands those responsibilities. It doesn't contract them. It goes in specifically in B, it ends that such excess shall be deemed a discrepancy and palpable error and shall be investigated by the superintendent, and no votes shall be recorded from such precinct until an investigation shall be had, which means you have to do something, right? And that continues. In C, addressing ballot boxes. If the ballot box is found to contain more ballots than there are electors registered in such precinct, or more ballots than the number of voters who voted in such precinct at such primary election, the superintendent may, again, may being discretionary, and this is important, in his or her discretion, exclude the poll of that precinct, either as to all offices, candidates, questions, or parties and bodies, or as to any particular offices, candidates, questions, or parties and bodies as to which such excess exists. D, the last sentence addresses the same kind of about further returns. Unless it appears by such number of calculations therefrom that such records and such general return correspond, no further returns shall be read from the latter until all discrepancies are explained to the satisfaction of the superintendent.
You said that's in D, D's not that long?
Sorry, E, Your Honor.
Okay.
D and E were close together. F.
They are next to each other.
They are very next to every time, Your Honor.
Yeah.
The last sentence in F, same issue. No further returns shall be read from the latter until any and all discrepancies are explained to the satisfaction of the superintendent. You know, we talked about G. Here, if the recount shall not be sufficient to correct the error, the superintendent may summon the poll officer to appear immediately with all election papers in their possession. I guess the logical thing is, and then what? Okay, you're here? Well, clearly they're here to investigate. And you know, it continues on. We've gone through sort of E and F, but the point is 21-2-493 fully expands and it clearly shows that she needs access to information as a board member. These are, and I think the court hit the nail on the head. You have the CEO or an employer asking an employee for information and the employee is withholding it. Okay, instead, we're having our Board of Election members having to make open records requests to get information that is what they are ultimately responsible for. Additionally, I feel that the county's argument's a little disingenuous when, according to 21-272, primary and election records are to be open to the public.
Does that mean ballots?
Well, you know, there's ballot images. I think the idea that Ms. Adams wants to open ballots, but we take tabs, we get images of them. That's something, frankly, even ballot images are now open to the public for review. So the idea that she has to wait in line or is denied any information, particularly when it's in digital form, is disingenuous. And it sort of brings you back to the, you know, the Shakespeare, either methinks I protest too much or something's rotten in Denmark, Your Honor. And so that perception is the exact counter as to what public policy has been for and what all the election laws have been in the last 4 years, because we're trying as a state to have greater confidence in elections, and clearly in Fulton County. And, you know, they spend a lot of time on this idea of fraud, but the standard, of course, is fraud, irregularities, and misconduct that places the outcome in doubt for an election challenge. So, you know, maybe fraud's a buzzword, but that's why it's in there. But it's really misconduct. Frankly, in some of the statute, it says mistake, which is
irregularity. Doesn't mean there was any bad intent. There was a hiccup in the system.
Exactly.
And that's a basis.
And she's on the board of the largest county in our state with the most voters. And sometimes you got to look, they said, oh, we're going to work together. We're going to give her everything. Look, history is the best predictor of, the past is the best predictor of the future. And frankly, day of, here you go, during a presidential preference, when is a far less turnout than you are going to have in this November. And so that is of great concern, and partly why we're at this inroads here, why we believe court intervention is necessary. There is an actual controversy. And you know, with that, I'll certainly yield and answer any questions the court may have. I know we've briefed you and you put up with us for 4 or 5 hours today, but which we appreciate the court's attention.
It has been a good educational experience for me. Let me see if I have anything else. Nope, that was helpful. I appreciate that as well. I think we're at a natural closing point. Mr. Siegelman, anything that your head is going to explode if you don't get to say it before we stop? That's really brief.
It is very brief. I feel it's somewhat prejudicial the way that the last comment was framed regarding OCGA 21-272, that all these records are open to the public and yet Fulton County is not providing them anyway. I'd encourage the court to look at what's been admitted exhibits, defendant 9 and I think 10, where we list all of the extensive election materials that are being provided, as well as the estimated time when they would be ready. And also that OCGA 21-272 specifically contemplates these records being handled by a custodian and that they are unavailable whenever necessarily being used by that custodian. So
necessarily being used what?
Necessarily being used by the custodian in accordance with their duties to conduct the election.
Sure, but that's sort of same team. It's this, I mean, 21-272 contemplates me being able to say, hey, I'd like to see some election records. And an election director saying, check with me in March because November is a bad time. And I get that. But this would be sort of same team. The custodian, I think, would be part of the electoral apparatus for Fulton County, of which the board is an integral part. So
Reason, Your
it's
Honor.
a little different.
Yes, and Your Honor, sorry not to cut you off. The reason why I framed it that way is because that was how opposing counsel framed it, was that why are we not getting it? It's available to the public. I just wanted to clarify that's not exactly what the code section says. And I also wanted to point out that, to your point, Your Honor, there is extensive election material being provided to all the board members, including Board Member Adams. And then finally, just this part about how 21-2-493 confers even greater authority. Everything that opposing counsel recited were these if-then statements where there has to be a discrepancy before this additional investigative authority is conferred. And to the statutory structure, there's nothing in the election code or in the Georgia code at all that contemplates a scenario where certification doesn't occur. Whereas there are specific things that have to happen after certification occurs. So I just want to make that consistency point. But thank you, for Your Honor, for the indulgence, and with that, I conclude.
All right. Mr. Volchek?
No, thank you for your time, Your Honor.
The court reporter says thank you, that you have nothing more to say. All right. This has been very helpful. Many of the Abhiraman people are gone. Thank you for your input as well. Obviously, these are important issues. Regrettably, they're pressing issues, which means I got to jump on it quickly. But I cleared my plate of some other stuff yesterday. So we will turn to that. A very likely scenario is an email from Ms. Niles. It will always go to everyone involved, not just to one side, saying, we'd like a little more thinking about this, or put together some paragraphs about that. And if we are laboring under any uncertainty or think a few more case citations would help, we'll certainly reach out, and we will take it from there. Any procedural questions from anyone from either of the two cases? Folks from the Adams case should make sure that they get exhibits to the court reporter in the same way that you all settled it in the Abhiraman case. Just let's be consistent in that way. Okay? Thank you, everyone.
Thank you, Your Honor.
Good to see you again. Oh, good to see you. Good job.
We have defendants. They're all here. Good. I'm gonna need like 3 minutes before we start. But you guys take your tables over as you flush them out of here. Do we have that virtual? Is Ms. Wood gonna be here? You would all be on Zoom? Okay. Oh, should we end this one? Okay.
Are you?